Good morning, everyone. I think the delay this morning was not as a result of problems here, but problems with the traffic, I think. But in any event, we're now ready to start. We're starting with matters relating to directions. And Mr. Rowett, would you like to open in respect of that?
Morning, Commissioner. Can I begin by introducing...
Your microphone is on mute.
Okay, hopefully that's everyone can hear me, but can I first of all start by introducing the legal representatives for all the participants?
Yes, thank you.
The Attorney General has participant status in her own right and also appears on behalf of a number of elected ministers. She is represented today by the Solicitor General.
Just wait a second, Mr. Rowett. Very much. I'm sorry, Mr. Rawat. Do you want to start again?
Yes, I shall. Then to begin again, Commissioner, just by introducing the legal representatives for the participants. As you know, the Attorney General has participant status in her own right, but also acts on behalf of a number of elected ministers. She and they are represented today by the Solicitor General, Miss Joanne Williams-Roberts, by Mr. Nicky Olympitis of Withers BVI, and by Miss Sarah Jane Knock of Withers BVI. You have also given participant status to 7 members of the House of Assembly who are separately represented, and their legal representatives today are Mr. Richard Rowe and Mr. Denniston Fraser. They are, as you indicated, sir, at the beginning when you began this session, a number of matters which we need to deal with before we can begin to hear evidence. And I would propose, with your leave, that we deal with those on an issue-by-issue basis.
Yes.
The first issue arises from a letter which was sent in incomplete form by Silk Legal on the 8th of June 2020. The complete letter was sent the following day. In that letter, 2 points of principle are raised, which, if right, would have some impact on the way that hearings are conducted. The first point is that the COI rules, which are the rules that you have published relating to the conduct of your investigation, and that the rules on how witnesses will be questioned are inconsistent with Section 13 of the Commissions of Inquiry Act 1880, which is the section in the Act which provides for the examination of witnesses. And the second point is that Section 13 is itself incompatible with the Constitution of the Virgin Islands 2007. Upon receipt of that letter, Silk Legal were asked to provide written submissions on all the matters that they had raised, together with any documents and authorities relied upon. They were directed to do so by 12 noon on Friday, the 11th of June, 2021. At 5:43 p.m. on Thursday, the 10th of June, Silk Legal sent an email explaining that because Friday was a public holiday, it was, quote, impossible, end quote, to provide any submissions. In reliance on the Interpretation Act, Silk Legal submitted that their written submissions would only fall due today, Monday, the 14th of June. The same argument was separately used to explain why the position statement from the Leader of the Opposition, the Honourable Marlon Penn, would also only be provided today. You, sir, having twice extended the deadline for submission of that position statement, and Mr. Penn having agreed to provide it by no later than Friday, the 11th of June. Mr. Penn, in fact, submitted his position statement yesterday, only for it to be retracted later in the day and then resubmitted. Written submissions were received from Silk Legal at 8 p.m. last night, which were then withdrawn and then resubmitted at 10:13 p.m. I would now invite you, sir, to ask either Mr. Rowe or Mr. Fraser to address you on 2 matters. The first is why the Interpretation Act permits non-compliance with the direction of the Commission, and specifically which section of the Interpretation Act is relied upon. And secondly, the argument that the COI rules and Section 13 of the Commissions of the Inquiry Act are unlawful.
Ready, Mr. Rowe.
Thank you.
Mr. Rowe, there are those two matters, and really the second of those matters, I would also put under that same umbrella the submissions that you made yesterday evening as well, which fill out that, I think. There are two other matters raised in the same letter to which Mr. Rawat has referred. One is revisiting a matter which has been dealt with a number of times, a complaint over the Foreign Commonwealth and Development Office being a data processor, and secondly, a complaint over the tone of the COI's correspondence. But perhaps we can deal first with the Interpretation Act.
Indeed. Section 16 of the Interpretation Act, Commissioner.
And where do I find that?
We don't have a copy here, we'll produce it. But before I begin, may I ask this question? And this has concerned me a bit as an additional magistrate in this territory. The Legal Profession Act requires that persons participating in this commission be called to the BVI bar. It has come to my attention that this may not be the case. And I ask, Commissioner, if certainly the participants as barristers and solicitors, whether they have been called to the bar, and if for the purposes of our client, they may satisfy us by indicating, by providing, through your permission, copies of the practicing certificates.
For participants?
Yes.
Right. Mr. Olympitis, I think a matter for you. You're the only other participant here.
It is.
I can produce one myself.
Right. And what about?
Not the participants, all the parties. Mr. Roat included.
No, just hold on a minute. Hold on, Mr. You're the only participant here. There are three of you here at the moment. The Solicitor General, I assume that she's got a practicing certificate.
That's correct.
And you and Miss Knock.
We have current practice.
Right. Those are the participants, Mr. Rowe.
With respect, Commissioner, we have been subject, Mr. Roat in particular, has been participating in this process, although it is inquisitional, in who we could equate to be the main inquisitor. That act is a practice of an attorney, of a barrister in the Virgin Islands. As I understand the Commission of Inquiry, which itself speaks to the requirement that attorneys be involved. And attorneys here would speak to barristers and solicitors. That would include the main inquisitor and his supporting staff. One of the requirements in going to answer the second question was that we provide 6 copies of the bundle for the very brief submissions that we have.
I'm sorry, have we moved on from your first point, Mr. Rowe?
No, I'm still on it.
Okay,
And the point is this, that we have been asked not only to provide electronic copies of the submissions, but 6 physical copies. Unless that is, I'm sure it's not. I'm an ecologist. I don't like the waste of people. Unless it is, one can easily presume or assume from that there are 6 other participants who need to be provided with copies of our legal submissions. This inquiry falls under the Constitution of the Virgin Islands, British Virgin Islands. This commission is authorized by the governor under powers given under the Constitution of the Virgin Islands. And it operates according to the rule of law, something we all obtained, I think, first in the Caribbean in Nevis, as the late Archibald QC, when he brought us to show where it was received at the courthouse there. And if it is so, there must be a presumption, or we can inquire elsewhere, that those participating in this commission of inquiry on this constitutional issue, that they too should be properly called to the bar of the Virgin Islands in accordance with the Legal Profession Act. Or if not, have committed a criminal offense, the penalty of which is up to $10,000. But this is an inquiry. And I ask it because it has been raised, and I'm sure, Commissioner, this is something you would want to look into yourself to determine if it is so.
And which provision of the Legal Professions Act are you referring to, Mr. Rowe?
I think it's, if I recall, it's section 16, no, 17, section 18.
And have we
18 and
got
19.
copies of that?
No, I don't have that with me here because I'm raising a question and I can supply it. And then again, you see, Commissioner, those who are coming to practice law in the Virgin Islands must be au fait with the law of the Virgin Islands. And as the law indicates clearly, ignorance of the law is not a defense. It is expected that anyone coming here to practice in these Virgin Islands research the law, make themselves aware of it, and apply it. So that I presume, that I assume, would have been the very first act before anyone would dare come before this commission and seek to hold themselves out as attorneys, as barristers, solicitors, attorneys, whatever. No, it's to deal with the second matter.
Can I deal with the first matter?
Oh, certainly, if you as you wish.
As I understand it, no, you haven't put anybody on notice that you were going to raise this.
Do I need to, sir?
Have you put anybody on notice?
No, sir.
Okay.
Do I need to? As I've raised it as a question publicly.
I'm aware of recent decisions of the Court of Appeal and the Commercial Court here, which concern the scope and effect of Section 18 of the Legal Profession Act 2015, which is, I think, the section that you're relying on. And in particular, these decisions concern the practice of BVI law by persons who are not registered on the roll of BVI legal practitioners. I've considered this, and I don't consider that the work being undertaken in support of the Commission of Inquiry, as opposed to participants, to be practicing, to be the practice of BVI law, or work caught by the provisions which are intended to protect the public from the unlawful practice of BVI law. Nevertheless, I do consider that it's appropriate for those assisting the Commission of Inquiry who are eligible for admission as BVI legal practitioners to be admitted and to obtain practicing certificates. And consequently, I will direct that appropriate applications are filed. I should say, Mr. Rowe, that in terms of Mr. Rawat, who you particularly mentioned, he was, of course, appointed to his role by the Attorney General.
As I understand and read, Commissioner, by your direction, I was not here, but certainly from what I received in terms of the orders, that is what was at your direction.
What?
His appointment by the Attorney General.
No. Under the Act, as you'll know, under the Act, as you'll know, the appointment is usually made by the Attorney General, and the Attorney General appointed Mr. Rawat on my recommendation.
Yes, you see, Commissioner, here is the problem. Put it simply, the Attorney General and I understand and sympathize greatly with the position in which he's placed. The Attorney General is been recommended by the Judicial Services Commission and appointed by the Governor. Her role is to act as advisor to the Governor and also to advisor to the legislature, two separate arms under the separations of power. Here it is, in essence, that the Governor is investigating another arm of the government, the legislature. Her position is an inevitable one. Because
Mr. Rowe, we've dealt with this before. We've dealt with the potential conflict of interest of the Attorney General, and she has dealt with that in hearings before me. What's the point, Mr. Rowe, that you're trying to make?
The point you're making, sir, is that even the very appointment of Mr. Rawat is something that we think might be amenable to judicial review.
But I mean, with respect, he's been appointed by the Attorney General. If you wish to judicially review his appointment, first, it may have been something you could have done some time ago, and secondly, you'll have to judicially review the decision of the Attorney General to appoint him.
And here comes another problem. If actions in the Virgin Islands, whenever a government body, minister or otherwise, is instituted, automatically involves the Attorney General. So if we sue here, I'm not sure what the practice in England, if we sue a government department for a negligence of a driver, say for the public works, who involves themselves in an accident, we have to, by course of practice, also include, within the 6-month period, limitation period we have, the Attorney General. And here it is, wherever we find ourselves turning to apply the rule of law within the course of this inquisition, we find blockages regarding the Attorney General.
But you've made those points. But more recently, having made those points, you've said that all of your clients have full confidence in the Attorney General, and indeed you're cooperating with her.
That is so in terms of operating through the operation of the commission of this inquiry.
But are you saying that in some way the Attorney General has a difficult constitutional role?
She has an almost impossible constitutional role as is, sir.
And does that affect governance?
It affects governance, as I will go on.
But why haven't you, when given the opportunity by me, put in submissions that that is a problem with governance in the BVI?
That is a problem with governance. I, sir, I'm not a witness in this inquisition. I'm an attorney acting.
So, but I'm sorry, I'd assume that the submissions you were making were made on instructions.
The submissions I'm making are made respect to law.
But are they on instructions?
Instructions regarding disposition?
Oh
Oh yes, almost definitely.
Right, good.
In fact, are being raised by the speaker at the conference with the Commonwealth Association. No.
And so can we take it that any issues that the speaker has with regard to this will be found in his position statement on governance?
His position statement on governance, I gather that what you have asked, Commissioner, I use the word asked because it is a request. It is not a demand. It is not a summons. I would even act properly made under this summon rules because you've asked a question which, frankly, to use their terms, would be best directed at a lower form high school student. That's just how they perceive it. What is your views on governance? Such a general view.
Sorry, that was not one of the questions. The question is, what is governance? What is good governance? What is poor governance? And so on. But in any event, Mr. Rowe, I have had responses to that request.
Certainly.
I've had a response from the speaker.
Yes.
Did he raise an issue about the role of the Attorney General in governance?
That was not an issue raised there.
But Mr. Rowe, where are we? We've got witnesses waiting. We have quite a long list of matters to determine in terms of directions. Where is this going?
Where is this going, sir? Let's go further to the second point. The submissions.
I'm sorry, my second point or your second point?
Your second point, sir, regarding these documents, the direction.
But we haven't dealt with the first point yet, which is the Interpretation Act.
Section 16, sir, requires, indicates.
Where is Section 16? Where do I find Section 16?
We shall be happy to provide it to you. In the same way that we would assume, and I think probably rather wrongly, that those participating in your support are au fait with British Virgin Island laws.
So what does Section 16 say, Mr. Rowe?
It's, in a sense, what it says this, where a directive...
Not in a sense. What does it say?
It says that where one is directed to make service on a public holiday, particularly when following that public holiday, it's a weekend, a Saturday and a Sunday, the document is due on the next day. If it itself is not a public holiday, that in this case being today, Monday. That's what it says, sir.
Okay.
If I may go further, sir.
No, just one moment, Mr. Rowe. Mr. Rowe, can you help on this? Mr. Rowe doesn't seem to have the section.
Commissioner.
We wrote the letter indicating that. We set up the section to him.
The Interpretation Act, as I understand it, was introduced in 1991. There was an amendment in 2014 that replaced the Section 16 of the Principal Act. And Section 16, as replaced, reads, an enactment or provision of an enactment shall commence or come into operation where a particular day for its commencement or coming into operation is specified by the enactment or by a proclamation or notice made under the enactment on the expiration of the previous day, or B, where the day of its commencement of coming into operation is the date of its publication in the Gazette on the expiration of the previous day. So it doesn't appear that the Section 16, as introduced by the Amending Act in 2014, is the statute which is the provision on which Mr. Rowe is relying.
Because it relates to enactments.
Yes.
The communication to your secretary, Commissioner, set out the provision of the Act. And that letter, I'm sure Mr. Ruat has, because he has quoted from this morning.
The letter of the 8th of June.
Yes. The copy here. A letter of the 4th of June.
So which is the section, Mr. Rowe?
Find it and confirm it now.
Mr. Commissioner, if it helps, I've just looked at the 1991 statute, and section 16 there is again still refers to the coming into force of an act.
Yes.
And to assist Mr. Rowe, the letter of the 8th of June didn't refer to a particular section of the Interpretation Act, merely the Interpretation Act.
We'll be happy to provide it for you in short.
Provide
Short,
what?
provide it section for you in short.
For what? Which section?
The Interpretation Act and the relevant section, which outlines the points I raised.
So is it not section 16?
And it seems not to be. I can't find here. That would have been done by the junior. Anyway, I'm not throwing anyone under the bus.
Perhaps if I could help.
Yes.
If we go back to the 2014 amending statute. If I could,
Go get it.
if just to help, perhaps it might
Certainly,
narrow the
appreciate
searches. The 2014 Act amending the Interpretation Act of 1991 replaced section 39. So section 39 now reads 39(1). If in any enactment or statutory instrument, a period of time dating from a given day, act, or event is prescribed or allowed for any purpose, the time shall be reckoned exclusive of that day or of the day of that act or event. 2. If the last day of a period of time prescribed or allowed by an act or statutory instrument for the doing of anything falls, A, on a Saturday or Sunday, or B, on a day that is a public holiday, the thing may be done on the first day following that is not a Saturday or Sunday or a public holiday, as the case may be. I pause there. I'm looking to Mr. Rowe to see whether that may be the section which he has in mind.
That's the section.
So,
sorry, and that section, what section is that?
It is section 39 of the Interpretation Act 1991 as introduced by the 2014 Interpretation Act amendment.
But does that only apply to enactment?
On my reading of it, it's if a period of time is prescribed by an enactment or statutory instrument, then that's when the section bites.
No, quite. But my directions, Mr. Rowe, important and powerful as they are not an enactment.
You're the practicer. They're obviously, you are a privy councillor, as I understand it. The law in the Virgin Islands ends with you in that capacity. The practice, particularly for us, let me indicate. Firstly, on the public holiday, having run out of paper, there's no way we could have produced and served to you because no place was open to purchase paper for the 6 bundles.
Just wait a minute. We're not dealing with that at the moment, Mr. Rowe.
No, I'm answering your answer.
We'll come on to the.
We come on to the practical. The practical thing, my lad, Commissioner, is that directions are given. Directions are given, particularly when members of the House have on several occasions advanced the necessity of a meeting to better coordinate the activities of this commission. It is only recently that a meeting had been called with council, of the council involved, so that there be a coordination. At this time, there are 3 matters that we have in the High Court which are continuing now. There are those matters, the 6 persons, whoever it may be, that need these documents, solely concentrate on this commission. We are practicing counsel within the Virgin Islands, are directed to meet when the very democratic practice in the courts here is that there's a consultation with counsel as to whether you can meet these deadlines. What we are receiving,
I'm sorry, Mr. Rowe. I'm sorry, Mr. Rowe. What you're saying is model thinking. The first issue is whether the Interpretation Act meant that the submissions were not due on Friday; they were due today.
This is our interpretation.
My understanding is that you accept that that's not what the Act says, but you say that that's the practice in the Virgin Islands.
Indeed.
Okay. Right. So it's not the Interpretation Act.
It is its understanding of the Interpretation Act and its application in the Virgin Islands that we apply.
Okay. Well, I'm going to apply the Interpretation Act as opposed to what you said it meant. And the Interpretation Act is clear. The submissions were due on Friday. The submissions were made at 10:13 p.m. last night.
Indeed.
That was not helpful. In future, Mr. Rowe, I expect directions to be complied with. If you are not going to comply with them, then I expect an application to be made for an extension of time. The Attorney General has made many such applications. I think it's right that I have agreed all of them.
Indeed, so
but no application from you in this instance. That, at the very least, was a discourtesy. But also, you are bound as a legal professional here to assist the Commission of Inquiry and to have submissions sent to us late in the evening, the day before a hearing, is not helpful.
May I apologize for the feeling, sir?
Yes,
but may I ask, as in an instance last week, where no documentation has been sent to us at all for submissions, that this discourtesy, we not be recipients of the same from
which documents, Mr. Rowe?
On the submissions made by Ms. Fiona Forbes Vanterpool, which I was asked to respond to, which were sent to me the morning of the hearing.
With respect, I'm sorry, Mr. Rowe, with respect, yeah. They were sent to me the morning of the hearing. They were sent to us the morning of the hearing, and she was trying to comply with a very tight timetable. Those submissions, as it happened, were extremely useful. You got them at the same time as us.
So what I'm raising, Commissioner, is that for the smooth operation, it might be helpful if we coordinated, if we consulted each other, where I'm open 24/7.
But Mr. Rowe, I made a direction. It was open to you under the rules to apply for extra time. You didn't. You should have done. You accept that. Had you have done so, then we may have been able to deal with the matter. You made no application. That's the way the rules work. Now, can we go on to the next matter, which is the COI rules, which you say are unlawful, Section 13, which you say is contrary to the Constitution, and also the recent submissions. Can I just start with the recent submissions? In those submissions, you refer to the salmon principles, which were set out in the report of the Royal Commission chaired by Lord Salmon in 1966.
66.
And those principles were, as you've indicated, approved by Miss Justice Mitchell in a case from Antigua and Barbuda in 2003, and you've cited that case. Now, I know you refer to that jurisprudence as quotes modern, but as you'll know, the salmon principles have been the subject of considerable criticism in the last half century, and in any event, they're only an expression of what we now call the requirement for procedural fairness. And in any event, in those 6 principles, principles 2 to 6 do not bite until what you refer to as, quote, allegations have been made in respect of a particular witness. And none as yet have been made in respect of your clients, so they don't bite. They're simply inapplicable. But Mr. I've been at pains to emphasize from the outset of the Commission of Inquiry that I am not conducting a trial. I'm conducting an inquiry, an investigation, and we are still in the investigative stage of that process. That's a stage which no doubt could have been done in private. I wish that process to be done in public, and it is being done in public. This week and next week, the focus of the inquiry is on governance, on state governance. That is the process whereby public decisions are made and implemented. In terms of registration of interests, which we're dealing with this week, I'm interested in the system, what it is and how it works. But that can only be done in the context of evidence from individual members of the House of Assembly, current and past. As you know, because you represent 7 of them, they have been asked a series of questions. Those who have responded, not all have, but those who have responded have said generally, perhaps in every case, but certainly generally, that they have been compliant with the declaration requirements at all material times. Now, if the evidence from them this week, however, when we hear from them, suggests that they are in fact in breach, then maybe a stage when I will have to consider the steps I take to make sure that the process in their regard is fair. One way of doing that, just one way of doing that, would be to write to them, setting out what the evidence suggests and giving them an opportunity to add anything they wish to add to what they've said this week before we go further. They may want further steps to be taken. They may want other witnesses to be called, for all I know. But what I propose to do is to hear submissions on that from you and from the Attorney General at the end of the week as to the best form, if appropriate, to the best form that those steps may take. But we're not there yet. There is nothing to put to any of your clients, or indeed any of those at the Attorney General. All we have at the moment is a set of documents and their responses to the questions we've asked. Their responses are, as I've said generally, we are compliant. It's only if they're in breach of anything that we may have to consider further steps. What those steps might be, for now, I certainly don't accept that they have to be rigidly in accordance with the 6 principles that you've set out. But what's important is that they're given a fair opportunity to respond to any suggestions that may be made against them.
And I greatly appreciate this, Commissioner. Particularly if you look at submissions line in the 8th paragraph, that Mr. Roth has been very careful to say, I will not at this stage be putting anything to you or accusing you of anything. And we have observed that fairness throughout this stage. But it appears, sir, and I go back, you've indicated earlier to me when I suggested that this was a fishing exercise, that you were, your words, if I quote them precisely, I was here to see if there was any fish.
But what am I supposed to be fishing for? All I want to know is this week how does the system work?
Yes.
Does the system work?
And you see, it is in that regard that number one of the Solomon principles concern us. Number one reads, before any person becomes involved in an inquiry, the commission must be satisfied that there are circumstances that affect him and which the commissioner proposes to investigate.
But Mr. Rowe, we can't go backwards. We've dealt with that. Your clients are participants. You applied effectively under that paragraph. You applied for participant status. You have been granted participation status.
See,
that's
indeed,
that.
Indeed. What that infers, Commissioner, is that there are clearly, and I'm sure our governor would not have instituted this commission, not appointed you, had there not been particular concerns with respect to our clients that they wish to investigate.
Your clients applied for participation status on the basis that they were involved in governance. And that is the basis upon which they were granted participation status. They are involved in governance. Governance is central to paragraph 3 of my terms of reference.
And I note, Commissioner, and I note happily that in terms of the future, that your areas, that you're indeed going to be investigating areas which fell under the purview of the governor himself.
Yes, because he's also involved in governance.
Indeed.
But there was never any doubt about that.
Indeed. That has only come to us with some satisfaction with recent communications that the commissioner of police will be called DPP, etc.
But they are centrally involved in governance and the operation of the law enforcement and justice systems, which are paragraphs 3 and 4 of the terms of reference. But I don't know why anybody thought that they would not be involved.
Would that as well, Commissioner, involve, and we wonder the wide ambit of this inquiry, whether that will involve calling the Chief Justice of the OECS as well, because within the region, to use a colloquial term, the buck ends with her.
The Chief Justice has in my view, has a role to play in governance, and she will be given an opportunity to make her observations in relation to that.
Indeed, indeed. So as I would then, sir, happily at this stage, although we'll provide them with our apology, make our application at the end of the week, as you have suggested, with respect to these 6 principles, as you have I think, sir, quite positively indicated, we'll have an opportunity to put suggestions to you as to how further proceedings.
But depending on the evidence, we haven't heard the evidence yet. The evidence may be that all your clients are compliant.
Indeed, 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 indeed. So if and so that arises,
before we come on to bundles, which really is a separate issue, I think.
Indeed.
Can we just deal with the 2 other matters that your letter raised? Firstly, there's this issue about the FCDO being a data processor. I thought we had dealt with that. I thought we dealt with it more than once. It's certainly dealt with in a press statement.
We, as I indicated, sir, are creatures of our clients' instructions. And we note and we have pointed them to the published discussions on the issue. There still remains amongst them some cause of concern given the close society that this is. In fact, the true Virgin Islanders may comprise no more than 15,000 people, all interrelated, and may open them to concerns about their own safety and privacy.
Yes.
And what it is that concern, I suppose we could deal with it on Friday as well. But it is concerns about that in this very close society that they have concerns about.
In terms of the FCDO being a data processor, I have dealt with that in the past. It's dealt with in the press notice. The data are secure.
Thank you. We honor and express that again to them.
Thank you.
The second point.
And finally, there's a complaint over the tone of the Commission of Inquiry correspondence, and I assume that's come from your clients and not from you.
No.
The tone is formal. It is not intended to be discourteous. I don't consider that it is possibly discourteous, but it is certainly not intended to be discourteous. It is a formal tone of correspondence that we have maintained to whomever we have written, whether it's the Premier, who has raised no complaint, the Deputy Premier, who's raised no complaint, the Ministers, who've raised no complaint, the Governor, who's raised no complaint, the Deputy Governor, who's raised no complaint. So perhaps you can also give your clients comfort that no discourtesy is intended.
Indeed, indeed. That, sir, would conclude, I think, issues we've raised.
Can we just deal with bundles? Again, Mr. Rowe.
Yes, the bundles are here. The submissions are very short, 2 pages.
Yes.
And I think rather than quotations, the points we submit on are less than a page. So we have 6 copies here.
Thank you. You'll appreciate that one reason for requiring the hard copies is the lateness of submission.
No. It would have been impossible, sir, on Friday.
Okay.
Please appreciate that sincerely. On Friday, with no paper in office, no place to purchase, that it would have been impossible to produce as small as these were.
Yes. But we've dealt with this. It would have been possible to make an application.
Indeed.
No application has been made. You have apologized. I have accepted the apology. We can move on, Mr. Rowe. Mr. Rowe, bundles. Could you perhaps?
Certainly, Commissioner. If I could just raise the again issues that have been raised in correspondence concerning the provision of bundles, and these have been raised by both Silk Legal and by the Attorney General. They fall under 2 heads. First is the provision of witness bundles in advance of hearings, and the second is the question of documents within the bundles referring to personal data and other potentially confidential information. As to bundles being provided in advance, there are 2 matters that need to be mentioned. First, the practicalities. Documents are being provided late. Often they're incomplete, and as the BVI government has accepted, sometimes in very poor order. To give an example, Commissioner, the next topic after the ones that we are due to start today, that the inquiry will focus on, will be the question of governance and the operation of law enforcement and justice systems. The main documents that will inform that topic will be the position statements that have been provided by those with a particular interest in these matters. However, at present, several position statements have yet to be lodged, applications for time having been sought and granted. Could I pause there just to echo the point that you made earlier to Mr. Rowe? Throughout the course of this Commission of Inquiry, you have received multiple applications for extensions of time. it is right that none have been refused. Perhaps it may ease Mr. Rowe's mind that these applications don't have to be made in any great formality. They are often made by email, a short explanation is given, an alternative time is offered. It is not always a date that you can accept, but you may extend time for a shorter period. The COI has noted, however, that there is also recent press reports of government departments being sent a request from the Commissioner on a Friday afternoon and being asked to deliver a response by Monday. That, to my knowledge, has never happened. It is right that we do operate on short timelines, and we do require the cooperation of those to whom we made requests. But that is an inevitable consequence of the overall timescale within which we operate. And as I've said, where those to whom subject requests are sent have come back to the Commission and asked for more time, it has been granted. To turn to the position statements that have been lodged, and again, this is to return to the practicalities concerning bundles. The position statement that was submitted on behalf of the elected ministers does contain unredacted personal information. It also raises issues, notably criticisms that the Governor and the UK government have acted unconstitutionally, in respect of which full disclosure has not been given by the ministers. The Commission requested that that disclosure be provided by Wednesday of this week. Those documents, when they are received, will inevitably require analysis so that we can identify any documents which may then need to be disclosed to others or to be put into a bundle for a witness. But in any event, what I would make, a point I would make is that, and this perhaps goes back to the submissions that you received on the salmon principles, there is no requirement to provide witnesses with all documents in advance. What the obligation is, and in my submission, it's the obligation that informs this entire Commission, and it's an obligation that you have publicly reiterated time and time again. The obligation is to ensure that each witness is dealt with fairly. And this was raised at the start of the hearings. It has been raised in more than one hearing, and you, sir, have made the point. The reason for raising it now is because in relation to bundles, we will have to act flexibly, and we will, what needs to be disclosed to a witness. And it is not only so that that witness is being treated fairly, but so that we can get the best evidence from the witness, will have to be determined on a topic by topic basis. So I've referred to the topic concerning governance and law enforcement and justice. Obviously, the position statements are at the heart of that topic. But by contrast, if we take the topic of interest, which is our first topic and the topic we are canvassing this week, many of the documents to which witnesses will be referred to are documents that have been provided by themselves. And so whether or not they receive a bundle in advance isn't perhaps as pivotal, because ultimately, we are asking questions and seeking information from them about matters that are within their own knowledge, and about documents that at one time would have been in their possession and control. And above all, perhaps the point to emphasize is the point again, sir, that you have made, is that it falls to you, and it is an obligation you have made clear you will adhere to ensure that each witness is going to be treated with procedural fairness. And we must all bear in mind that these witnesses are your witnesses. They are not here to advance a particular case. They are here to assist with your investigation. To turn to the question of confidential information, we have a redaction policy in place that is published, and it is available on the inquiry's website. Again, this will have to be done. What material is provided to participants, to witnesses, participants, but against whom an allegation may be made, will have to be determined on a topic-by-topic basis, keeping procedural fairness in mind. What I would remind all those involved with, and that is not just the legal representatives, it is participants and witnesses. And it is this, and this is found in the COI rules. Everyone owes the commissioner an obligation of confidentiality.
Okay.
If a document is provided to a participant or to their legal representative, it is under that obligation, and they are bound by that obligation until released from it by the commissioner. In terms of the use of confidential information, it is unlikely that it will be necessary to refer to much, if any, of material which is considered to be confidential. But if reference needs to be made to it, that can be dealt with shortly in private session. And you made the point at an earlier hearing that although the public hearings are going to be live streamed because of the importance that you have placed on the need for transparency and for the working of the commission to be seen and followed by the BVI public, that is subject to a 3-minute delay.
Sure.
And that allows any legal representative or any participant or even the witness to raise a question, which can then be resolved by you as commissioner in private session. If the matter is one that can then be resolved such that the information can be considered publicly, then when we resume public session, that can be explained for the purposes of the transcripts so that any members of the public following have a full awareness of what has been determined and what direction is to be taken. That's all I wish to say in relation to bundles. I don't know whether there are matters that you may wish to raise, Commissioner.
If I may add, Commissioner, to
Just
one
one
thing.
sec- just one
No,
second.
to one supporting point.
No, we'll hear all supporting points
Okay.
that you want to make, Mr.
One
Wright.
supporting.
I just want to crystallise that into two propositions, I think. Firstly, each topic that we deal with, we will have to deal with bundles, the arrangements for bundles in respect of that particular topic, because the criteria, the circumstances will be different. And secondly, there is material in the bundles for this week, and certainly in the bundles that are likely to be prepared for next week, that will be confidential, either because they contain personal data or for other reasons. But if they are given, just sticking with the participants for the moment, if they're given to participants under their obligation of confidentiality, then any issues that arise during the course of a hearing in relation to a particular element of confidential information, if it arises, can be dealt with then, if necessary, using the 3-minute delay.
Certainly.
Sorry, Mr. Rowe.
Yes, just to indicate, so that certainly the topic for this week, the information is public, and by amendment to the law, even more so. So we can understand that with respect to these. So to support his submission.
Yes, thank you. Mr. Olympitis, any observations at this stage?
I've got a couple of comments, sir. In relation to bundles, I mean, it's good practice for participants to have as much advance evidence as possible. And there was a point that the Attorney General made in her letter of the 10th of June in order to get bundles for this hearing. And fortunately, we were supplied with the COI's bundles. So
but
we're grateful for that.
I agree with that point, Mr. Olympitis, but there are practicalities. Why having prior notice of bundles? You say it's good practice. It is helpful because it may shorten hearings, because the witnesses will be better acquainted, or maybe better acquainted with the bundle as it is. But there are real challenges when, and this at the moment is not a complaint. I may complain about it else on another occasion, but documents are coming in very late. And for example, for next week, we can't put the bundles together for next week because we haven't had full disclosure yet from you. So it's a real challenge. Just though, I know you have a second point, but just taking up the point about this week, Mr. Rawat, the individual bundles for this week, they are available, and can they be made available to Mr. Olympitis for those the Attorney General represents?
May I just have a moment, sir?
Yes.
I'm grateful to those who sit behind me, Mr. Commissioner. The bundles, as I understand it, for Mr. Olympitis' clients have already been provided to him. There are bundles here for Mr. Rowe in relation to his clients.
In relation to his clients, and those no, but I don't think there are any of Mr. Rowe's clients today.
Yes.
Well, that's a matter that we need to deal with
course,
a little later on. But we'll come back to that if I may.
We'll come back to that. But Mr. Rowe, you can have those files.
Appreciate it.
Yes, they're files, as Mr. Rowett said, of documents emanating from your clients or going to your clients.
And public documents.
I'm sorry, Mr. Olympitis, you had a second point.
The second point was really an observation. Mr. Rawat had said that all requests for extensions had been granted, whereas in fact our request for an extension in relation to Order 11 topics and extending the timetable for providing submissions on those issues, that was refused on the 7th of June. We're trying to do our best to provide submissions, but because we were planning on doing these at the end of the month. So we're trying to bring that work forward, and we will get to you. But the point that I'm making is that the order the request was refused.
No, just remind me, Mr. Olympitis, was that the order in respect of issues and witnesses for the topics?
That's right.
Yes.
And you had given a deadline. I don't have it with me, but you'd given us a deadline, I think, of the 7th of June for that.
Yes.
And we offered a different framework and timetable, and the response came back no.
But yes, because it would have rendered the timetable.
Our suggestion, sir, is that we do a rolling, try and provide it to you on a rolling basis. Again, I'm not sure that that's
but the point you make is a fair one. There is that one circumstance. Just looking forward to next week, Mr. Olympitis, can you help me on a couple of matters relating to the bundles? The direction was that the position statements and appendices be restricted to 50 pages. The position statement of the ministers, from recollection, was 32 pages, and an enormous bundle of appendices. I mean, several hundred documents. Two things about that. Firstly, why did you not comply with the direction, or alternatively not come back to raise the issue with the with the COI team, because the length of the whole submission and appendices was far over the limit. And secondly, that although the appendices included some disclosure on the matters raised in the position statement, as Mr. Rawat has said, some serious criticisms of the governor and the UK government in terms of governance, that they've acted unconstitutionally and unlawfully. You've disclosed a few documents relating to those issues, but clearly not given full disclosure. That full disclosure is now due on Wednesday, but it would have been helpful to have had the disclosure earlier.
So we took the view that this was a position statement. It wasn't a full disclosure exercise in the litigation sense. And we provided our position. Now, we've been asked to provide further documents. We are writing to you, and I'm hoping that letter will be received by you today. And we will be providing further documents. I can't promise that we can provide you with the full A to Z of the correspondence or what it is that you particularly would like to see, but we will do our best to provide you with some more documents.
Well, the documents I'd like to see are the documents which I might consider relevant to the issues that you have raised. But I mean, we look forward to seeing that.
Well, some of the
letter.
correspondence there may go over a period of 2 or 3 years,
Yes.
or even longer.
Yes.
And we'll do our best.
Yes.
To
Okay.
get there.
The second point that I'd like to raise with you, Mr. Olympitis, is I think it was on at the hearing of the 2nd of June. This issue was raised, and Mr. Hyrie said that instructions would be taken on it, and that's the position of the governor in cabinet. And this does bear upon his position statement. The governor is not a member of cabinet, although he chairs cabinet. He's not a member. He can't vote on cabinet matters. But it of course is open to him to express concern about a particular proposal that cabinet can and does vote on. And it's whether those expressions of concern would be the subject of any confidentiality. And
you're right, we haven't come back to you on it, and I think what we must do is write to you on the subject.
Again, because this is for next week,
Yes, I understand.
It means that at the moment we couldn't publish the governor's position statement.
Right. Well, hopefully we can get something to you pretty quickly, and perhaps it can be quite short as well.
Yes, good. Thank you very much. Anything else on bundles, Mr. Rawa?
Can I just come back to the points that Mr. Olympitis has made? I'm quite happy for the purpose of the transcript to correct what I said about
Yes.
extensions of time and say that there has been one instance since the inception of the inquiry that an extension has not been allowed. Although I would say that was for good reason because of the potential impact on the timetable. To touch upon the issue you raised, Commissioner, about why the position statement did not comply with your direction that it be limited to 50 pages. With respect to Mr. Olympitis, he didn't actually answer the question. He made the point that in limiting disclosure, it was done because it was deemed to be a position statement. Of course, I think there are two matters to remind you of, Commissioner. First of all, is that if one looks at the rules and the protocols, they reiterate, and indeed it's your public statements, that anybody who believes that they have material relevant to your terms of reference should act proactively to provide it to you. And the second point to make is that on the 10th of March, you wrote to members of the House of Assembly, for example, which include, of course, the elected ministers, and you wrote to them with an open invitation to provide you with any information or document that they have in their control and possession, which they might consider to be relevant to your terms of reference. Though that letter did not prompt from any recipient a detailed response or the provision of further documents. But I think it is right to say that from the very beginning, you have made clear that you will receive material from anybody that may be relevant. And it's particularly, in my submission, an important point for all participants to take on board. And that is because we are now in substantive hearings and we are working to a tight timetable.
Yes, Mr. Olympitis, just to say two things. Firstly, save for that one exception, time extensions have been given, but certainly participants and anyone else in respect of whom directions are made should not assume that extensions will be given in the future, given the tightness of the timetable that we have. That I think is the main point. In relation to Mr. Rawat's second point, I don't think there's anything else I need to add to that. Next, point, Mr. Rowett?
The next point, but we've touched on it, but but it's perhaps for the purpose of the transcript and those watching worth reiterating, and that is that it remains your intention, Commissioner, to publish position statements that are sought on governance and law enforcement and justice. But for the reasons that have already been explained, we're not yet in a position to do that. The next topic, if I may, to move on to, is the question of witness scheduling for this week. It has not been possible, and the Commission issued a press notice on the witness schedule to issue as yet a full witness list for the week. Just to set out some chronology, for the hearing of starting today, witness summons or letters inviting those who had previously given evidence, and in particular that was the Premier and Minister Wheatley. Those summons and letters were issued on Monday, the 31st of May, 2021. In the usual way, witnesses were all summoned to attend on Monday, the 14th of June, that is today, at 10 a.m, on the basis that a timetable for the week would then be worked out with input from the witnesses themselves. They were all asked to accept service by email. Generally, those represented by the Attorney General did so. Those represented by Silk Legal did not. On Tuesday, the 1st of June, after the summons had been sent out, and unbeknownst to the Commission, it seems that sittings of the House of Assembly were scheduled for several days in the week commencing the 14th of June. On Wednesday, the 2nd of June, when we had a hearing, you, Commissioner, announced that hearings would begin on the 14th of June with sittings on a 4-day basis, and that the first topic to be considered would be the interests held and declared by members of the House of Assembly and elected ministers. No legal representative present at that hearing mentioned that the House might be sitting that week, or if it were sitting, the days on which it would be sitting. Mindful that those that you were asking to attend to give oral evidence may have other commitments because to do with their duties as members of the House of Assembly or as ministers, they were each written to and offered dates during the week beginning Monday the 14th. The last two serving members of the House of Assembly to be formally served their summons were the Honourable Speaker Willock and Honourable Neville Smith, who were each served personally at 5:20 p.m. on Friday the 4th of June and at 10:20 a.m. on Wednesday the 9th of June, respectively. On Friday the 4th of June, Silk Legal wrote to inform the Commission that there were in fact sittings of the House scheduled for 15th, 16th and 17th of June. They confirmed on the 7th of June that members of the House had been informed of these sitting dates on Tuesday the 1st of June. The situation is somewhat confusing as those acting for the Attorney General were, as of that date, only aware of sittings scheduled for the 15th and 16th of June. And further, although we were informed by Silk Legal on the 7th of June that the sitting dates are communicated to the public via Facebook and the BVI Government's website, the only such communication that we have been able to find was a Facebook post on 9th of June saying that the sitting scheduled for Thursday, 10th of June had been rescheduled for Tuesday, 15th of June, and that the sitting would continue in committee deliberating the Contractor General Bill. I referred to Monday, the 7th of June. That was a council-to-council meeting, which was held between members of the AG's team, members of Silk Legal, and members of the COI team to work out a practical solution to listing evidence this week. Unfortunately, Silk Legal did not have instructions as to when, if at all, their clients or those that they represent were able to appear. If I pause there, I just want to touch on a point that Mr. Rowe made earlier, because he suggested that there be an element of consultation between legal representatives of the participants and the COI to work out practical solutions to matters that would ensure the smooth running of the inquiry. That is, of course, something that is routine in inquiries. It is a point that I have made at earlier hearings, and that is that we are available to speak to anyone who wishes to speak to us. But it only works if people turn up to the meetings armed with instructions so that we can resolve a particular problem. I should also add that what Mr. Rowe has been able to say today is an evolution of the stance that was adopted on the 7th of June. On the 7th of June, Silk Legal's position was that there should be chambers meetings. And by that, I take to understand that there should be private hearings or meetings in front of you, possibly involving different clients, at which these issues are resolved. In my submission, that is not a practical way forward. Firstly, because it moves us back to doing private hearings, which you have made clear is something that you will only now entertain in certain circumstances. Secondly, these are matters that are eminently solvable on a council-to-council basis, and they are not ones that need routinely involve you as Commissioner. Most of the witnesses that have been offered alternative dates have accepted them, and that was the basis on which we were able to publish the witness schedule that we have done. With the cooperation of the Attorney General, all of those whom she represents have now been scheduled on different days this week. Of those represented by Silk Legal, 2 have over the weekend accepted the alternative slots that have been offered. So there is a need to resolve the scheduling of the evidence of the following witnesses: the Honourable Alvera Maduro-Caines, the Honourable Mark Vanterpool, the Honourable Julian Fraser, and the Honourable Melvin Turnbull. We have been informed by Silk Legal that those 4 members will be attending at 10 o'clock today. And I see Mr. Rowe nodding towards me. Now, what I would suggest is that perhaps the most pragmatic way forward, Commissioner, is that you call each of those 4 witnesses briefly to seek to understand if we can resolve the issue of when later this week they can give their evidence. The other person that remains to be resolved is that of the Speaker, the Honourable Julian Willock. And perhaps if that's something I could return to in due course.
In relation to the members who are here, Mr. Rowe, sounds to me the best course.
Commissioner, part of council's duty is to be persuasive. And members of the legislature who we represent, notwithstanding their duties to the legislature on those days, have generally agreed to absent themselves, save one exception, save the Speaker, who has to be there. And he can make himself available, as I think our correspondent said, at 1:30 this evening.
Sir, I think there's a misunderstanding. The 4 members who are here, who you represent, Mr. Rawat suggests that.
Agreed.
Yes.
Agreed.
And then we can work out the schedule.
Agreed.
Yes.
I think we can confirm that only Mr. Mark Vanterpool.
No, not sure.
Not sure, wasn't he here?
He's here, sure.
But be sure about Mr. Vanterpool, if we could call him first. Because it may be that the others have already agreed to come on the suggested dates, which you could confirm.
Well, you're their representative.
Yes, certainly.
So you'll know.
If we could call Mr. Vanterpool.
So shall we call Mr. Vanterpool
Yes, Mr.
first?
Vanterpool, please.
Mr. Rawat.
I'm perfectly agreeable with that step.
Yes. Let's see Mr. Vanterpool. Thank you, Mr. Rowe.
Yes, we get him.
Mr. Commissioner, I wonder if we could just ask for a short break of 5 minutes, just so that we can set things up for the witness.
Certainly. I'll come back in 5 minutes' time.
Thank you.
for coming this morning. If I can just explain, all of this has been explained earlier this morning, but obviously you weren't here for this. We have this week, I think, 22 witnesses coming this week, and in the usual way, all are put on notice for the start of the hearing, 10 o'clock today, with a view then to organising a schedule for the witnesses during the course of the week. In respect of all but 5 witnesses, that has been done, you 4 and the Honourable Speaker. It's been impossible to arrange scheduling of your hearings. We have tried, we've corresponded with Silk Legal, we've had a meeting with Silk Legal, but they had no instructions. And so I think the only way, but certainly the best and most pragmatic way of dealing with the scheduling is for you to be sworn in. We'll organise slots for hearing your evidence this week. But I'm sorry that this has meant that this morning you've spent some time here, which otherwise you may not have spent here. You may have spent dealing with something else. Good. Thank you very much. And I think first, Honourable Mark Vanterpool, I think, is first.
Mr. Vanterpool.
Yes, Mr. Vanterpool.
I'm going to ask you whether you would like to make an oath or swear an oath or make an affirmation.
Affirmation.
If you'd like to take the white sheet and you turn it over and read the words on the sheet.
I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you, sir.
Thank you, Mr. Vanterpool. Just 1 or 2 things. Firstly, if you speak quite slowly and clearly, because it's all being transcribed, as you know, that would be very helpful. Secondly, you're not sitting next to your lawyers. We know that. That's due to COVID. We want people not to move around. We want people to move around as little as possible. I'm not sure that you'll need any assistance from your lawyers to deal with the scheduling, but if you do, please let me know and you'll have that assistance. Yes?
Appreciate it. Thank you, sir.
Mr. Rowett.
Good morning, Mr. Vanterpool. We need to deal with some formalities first of all, as we do with every witness. So can I ask you, just for the record, could you give the Commissioner your full name, please?
My name is Mark H. Vanterpool.
And your professional address?
Port Purcell Road, Town, Tortola, BVI.
And again, for the record, could you just explain to the Commissioner the current position you hold in the House of Assembly?
I am the representative for the 4th electoral district.
Thank you. What may follow now is that I hope that we will be able to find a time when you can come back and we can ask you some fuller questions on this topic. The purpose for now is to try and work with you, I hope, through questions to try and find a suitable date this week when you may be able to come and give that evidence. I'm not going to ask you any questions about that topic at this time. As the Commissioner explained, we have been endeavouring as the Commission to try and find suitable dates for witnesses. We are very aware that as a member of the House of Assembly, you will have other commitments that take up your time. Can I start off just by clarifying with you, you've accepted your summons, haven't you? And you appreciate you're bound by that summons?
Yes, sir.
Now, when did you first learn that there would be a sitting or sittings of the House of Assembly this week?
I don't have an exact date, but that was probably a week and a half or so ago.
And could you help clear up one ambiguity? Is the House sitting on the 15th, 16th, and 17th, or the 15th and the 16th?
I believe the sitting on the 15th tomorrow is a continuation of a previous sitting, and then we have a house sitting on a new house sitting on the 16th, and sorry, the 17th. I don't recall whether there was a specific one on the following day, but yes.
So certainly there may be commitments, as far as you're aware, for members of the House of Assembly on the 15th and the 17th.
Yes, sir.
Now, please correct me if I'm wrong, but I think the House, when it starts to sit, begins at 10 a.m. in the morning.
That is correct.
On the 15th, will you be engaged for the entirety of that day with House of Assembly business?
I can make this very simple for you. I am prepared to come before the sitting, the inquiry, any day of this week, at any time. I have made that request to the Speaker, so I'm available at any time.
Well, that's very helpful, Mr. Vanterpool, and it does shorten things. But what I would like to suggest to you, and I hope that is making it easier for you as well, is that you attend on Friday at 2 p.m.
Friday 2 p.m.
Friday 2 p.m. I'll be available. Yes.
Well, thank you very much. That's sorted that out.
President,
Mr. Vanterpool, thank you very much.
Thank you.
Thank you very much.
Appreciate it.
See you on Friday.
Thank you.
Honourable Julian Fraser, I think, next. Oh, yes. Could just one moment, Mr. Fraser. We're going to we'll just wipe down the desk.
So you are your friend, my friend.
Yes, thank you, Mr. Fraser.
Yes. Yeah, Commissioner, maybe possible for him to leave, Mr. Vanterpool?
Yeah, yes, certainly. Yes. Thank you, Mr. Vanterpool.
Thank you, sir.
Thank you.
Swear an oath or make an affirmation. Swear an oath. Let's fix it by on your right hand and repeat the words on the sheet in front of you.
I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you, sir.
Thank you, Mr. Fraser. Yes, Mr. Rowell.
Good morning, Honourable Fraser.
Come on.
Again, please, the formalities. Could you give your full name to the Commissioner, please?
My name is Julian Fraser.
And your professional address?
House of Assembly, Richard C. Smith, the Stout Building, Rotown, Tortola.
And your current position in the House of Assembly?
Representative for District 3.
Thank you. You will have heard the questions that I put to Mr. Vanterpool. The purpose of this hearing with you this morning is to try and find a date on which you can come this week to give evidence to the Commissioner. Could I ask, are you in the same position as Mr. Vanterpool has indicated, in that he was willing and able to attend on any day that the Commission?
A little different,
direct?
because on the 27th, I mean the 17th, which is Thursday, I have to give notice and I have to be there. However, I can be here any other day except Friday and Thursday.
Okay, that's good.
My preference would be to get this over with and be here tomorrow.
Well, could I propose to you that you come back on the morning of Wednesday, the 16th of June?
Wednesday, June 16th,
Yes,
What
at
time?
10 o'clock.
10 o'clock? You're going to be ready for me 10 o'clock?
We will be ready for you, Mr. Fraser, at 10 o'clock on Wednesday, the 16th of June.
10 o'clock it is, Wednesday.
Thank you very much.
Mr. Fraser, thank you very much for coming.
Before you leave, Mr. Fraser, there is one other matter I
Yes.
should mention. You have very helpfully provided a position statement on governance to the Commission of Inquiry, and we have written to you subsequently inviting you to come and respond to questions on that position statement on the 22nd of June. I just wanted to flag that up to you as a date on which we would ask you to return to assist the inquiry further.
I'll be here on that date. I just didn't, I saw that, I got the summons. I didn't know exactly what it was for, that it was for that purpose. I'll be here.
If I explain the way the commission is operating, once you've received your summons, it is a summons at large and you can be asked to come back at different times to give further evidence. Thank you very much for your time today.
Yes, thank you, Mr. Fraser.
Welcome.
Honourable Alvera Maduro-Caines next. Just again, one moment while we wipe down the desk. Thank you. Yes, thank you.
Good morning, Maduro-Caines. Would you like to swear an oath or make an affirmation this morning?
Affirmation.
If you'd like to take the sheet in front of you and turn it over and read the words. Thank you.
I, Alvera Maduro-Caines, do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Yes, thank you.
Thank you.
Good morning, Ms. Maduro-Caines. Can I ask you, please, to give your full name to the Commissioner?
Alvera Maduro-Caines.
I'm also ask you just to keep your voice up nice and loud because it is you are being recorded and there's a transcription made, and it's important that we record your evidence and your answers as clearly as possible. Could I ask now for your professional address?
Richard C. Stout Building, Wikamski, Rotown, Tartola.
And your current position in the House of Assembly?
Representative of the 6th Electoral District.
Again, you will have heard the questions that we've put to Mr. Vanterpool and Mr. Fraser, and they have all both been able to indicate that they can come at the times suggested by the inquiry. Perhaps if I try to shorten it, what we were proposing for you, Ms. Maduro-Caines, is that you come to give your evidence tomorrow at 10 a.m. Is that a time that is convenient to you?
I would have preferred on Wednesday. We have sitting tomorrow.
Who else is Wednesday?
Commissioner, if I can get Wednesday at the moment with other witnesses is a very full day. So we might be able to accommodate you later on in the day on Tuesday, if that would assist you.
Okay, I'll do Tuesday then.
Perhaps if I suggest a slightly later start for you, Ms. Maduro-Caines, would you like to come at about 11 o'clock?
If I come 10, chances I'll get through in enough time to go to the sitting.
I see. Thank you very much.
Just one moment, Mr. Howard. Is there any possibility of starting earlier, just to accommodate this member?
Well, we could start again at 9 if you wish, Commissioner.
Would 9 help?
Yes.
Let's sit at 9. It may be that we'll have a break later on in the day, but
yes,
at least then Mrs. Maduro-Caines will be able to get back quicker than you otherwise would.
Yes.
Yes?
No.
Thank you, Ms. Maduro-Caines. We shall see you tomorrow at 9 o'clock.
Okay.
No, thank you very much. Thank you. And finally, Honourable Melvin Turnbull. Thanks.
Mr. Turnbull, would you like to swear an oath or make an affirmation?
Affirm, please.
I'd like to take the sheet in front of you and repeat the words on it.
I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Turnbull. Yes.
Good morning, Honourable Turnbull.
Good morning.
Could I ask you, sir, please, to give the Commissioner your full name
Melvin Mitchell Turnbull,
and your professional address?
Richard C. Stout Building, Rotown, Tortola, British Virgin Islands.
And your current position, sir, in the House of Assembly?
Representative for the 2nd Electoral District.
Mr. Turnbull, again, hopefully to try and shorten matters and perhaps to get to the point, we were going to suggest to you that you attend to give your evidence on the matters under investigation at present on Tuesday afternoon. Would that disrupt your working commitments too much?
Because of the House sitting, I heard other members state various reasons, but because of the House sitting, I'm not sure where we would be on Tuesday. I'm hoping Wednesday would be either Wednesday or Friday. That would work for me. Because on Thursday sitting, I have questions before the House as well.
May I just have a moment?
Yes, certainly.
Slightly like a negotiation, Mr. Turnbull, but could I, as an alternative, propose Wednesday morning at 11 o'clock?
That will work.
Thank you very much for making it work.
Thank you.
No, thank you, Mr. Turnbull. Anything else for Mr. Turnbull?
Nothing, but thank you for your time.
Good. Thank
you
you
so
very
much.
much for coming.
Before I move on to the next topic in the for the purpose of the direction here, can I flag up one point?
Yes.
Mr. Rowe has kindly indicated that in relation to some of his clients, that there may be issues that may require an application that you hear matters in private session.
Right.
What I have indicated is that there will need to be an application for us to go into private session.
Right.
And obviously, Mr. Rowe and his team now have the schedule as to when their clients are coming. And
when is the first client coming to assist?
it will be Miss Maduro-Caines at 9 a.m. tomorrow.
Right.
So if
No difficulty with her.
no,
No difficulty with her.
well, I shall liaise with Mr. Rowe, and we can try and make sure that if there is going to be an application, it is made in good time and
Good.
with
Certainly.
minimum disruption to the hearing
Thank
schedule.
you very much.
Can we let-
Can I turn perhaps to the last of Mr. Rowe's clients, and that is the Honourable Speaker.
Yes.
The Speaker has not responded to his summons, which was returnable at 10 a.m. today. Before dealing with the practicalities of scheduling the Speaker's evidence, I would invite Mr. Rowe or another of his team just to address you on a point that they raised in correspondence, which is that Section 16 of the Evidence Act means that the Speaker was not required to attend a summons today.
Good. Thank you. Mr. Rowe.
Wait, please, Commissioner. What are these circumstances? The Speaker has been scheduled in an arrangement planned since 2019 to address the Commonwealth Association of Houses of Assembly. He has, through us, asked if it were possible for him to come at 1:30 this afternoon. That meeting is scheduled to end at 1 o'clock. We suggested to him that he had a half an hour to that to ensure that if there's any delay, that he got here on time. I spoke to my learned friend, Mr. Roth, and he has indicated that that might be difficult, but he certainly would wish to attend, given his particular function as Speaker of the House, to make arrangement for appropriate day when the House is not sitting to give his evidence.
We'll come on to that. The first question Mr. Rowett has raised is the reason why he's not attended, why he's not complied with the summons. There are reasons why somebody is not compellable under the Evidence Act, for example, a sitting of the House. There are other circumstances in which a witness may well be compellable, but may wish to change a date because something else pressing, he or she is engaged with something else pressing. Are you saying that at 10 o'clock today, he was covered by the Evidence Act and therefore was not compellable?
We are saying, sir, that's the second of those suggestions.
Right.
Because this is why, as we would have probably have done on Thursday to say, please extend. That is why our communication to the secretary was to indicate this alternate time today because of his previous commitments.
But you have no instructions from him in terms of when he might actually be able to attend to give his substantive evidence this week?
What I would suggest, sir, given what is happening here today, that his duties extend primarily to the House. The House does not sit on Friday. Friday would be a day when
he'd be able to come.
Yes, sir. He would have no excuse not to come. Doesn't matter.
Right.
He has to come.
Mr. Rowett, is Friday a day in which the Speaker could be accommodated?
Yes. Can I give this some context though?
Yes.
Firstly, up until the clarification that Mr. Rowe has provided now, it was the position of Silk Legal that the Speaker was protected by Section 16. And the difficulty was that Section 16 makes a member of the House of Assembly as not compellable to give evidence if that member would be prevented from attending a sitting of the House of Assembly or a meeting of a committee. And the difficulty was whether the function that the Speaker is attending today could be properly described as a meeting of the committee of the House of Assembly, and that has never been clarified. The second point is that at no time was there made an application to vary the date of the summons, and going forward, that is perhaps something that Silk Legal should take on board. In terms of scheduling the Speaker's evidence, we do recognise that as Speaker, he has an obligation to the House of Assembly and he has to attend and be present at all sittings of the House of Assembly. Obviously, there is a Deputy Speaker and there are provisions when the Speaker is away for others to sit in his place. But can I suggest that the Honourable Speaker attend at 9 a.m. on Friday morning?
At 9 before Julian.
Yes.
Okay, that's convenient.
Yes, and can I say this, Mr. Rowe? I appreciate that the Speaker has other obligations and important obligations to the House of Assembly. Those obligations are reflected in the Evidence Act, which means that he's not compellable when the House is sitting. He is compellable when the House is not sitting, which means that he's in willful default of the summons today. What I'll do is I will ask him to honour the summons 9 o'clock on Friday.
Yes.
Commissioner, before we confirm that, I should have checked that our AV support was available at 9 a.m. on Friday. I must say I've assumed that he's also, Mr. Peters is available every other day on which I've said 9 a.m. And I apologise to him for not checking before doing so. But right. Unfortunately, Mr. Peters, as you know, Commissioner, we are scheduled to sit Mondays to Thursdays. Mr. Peters will be available from 12 p.m. on Friday. And so we will need to start at
12 o'clock.
At 12 o'clock.
Okay.
So I'd suggest if the Speaker can answer to his summons for 12 o'clock on Friday.
12 o'clock instead. Okay.
That would be.
Thank you, Mr. Rowe. Thank you, Mr. Rowe.
Thank you.
Yeah.
And thank you to Mr. Peters. Those are all the matters that I wish to raise for the purpose of the direction hearings, Commissioner. I don't know whether there are any other matters that you wish to raise before we move to the evidence.
I don't think there is, Mr. Rowett. Before we move to the evidence, does everything have to be reconstituted and cleaned?
Yes.
Yes, I think is
Yes.
the answer. So I'll rise while that's done, and then we can get on with hearing the evidence.
Thank you very much.
Good.
Who do we have
Yes,
today?
thank you. Yes, Mr. Howard.
Thank you. So we are now in a position to start with the evidence that we will be calling this week, which, as you indicated earlier when we were dealing with directions, is concerned with the system by which members, in particular members of the House Assembly and elected ministers, have to deal with any interests, particularly including conflicts of interest. If I could start by briefly just outlining the legal framework that applies.
Yes.
I won't go into great detail of it, but again, it gives us the framework within which some of the questions that may need to be put will arise. Firstly, that under the Constitution, in its section 66(1)(f) of the 2007 Constitution, there is an obligation on a candidate who stands in the general election to publicly declare if they are in some way a party to a government contract. That does not stop the individual from running for office, but they have to make the declaration. The second element of interest is in relation to the Register of Interests Act. The Constitution again provided for a registrar of interest to maintain a register of interest, and that has been in place. The statute implementing that part of the Constitution has been in place since 2008. It has been amended twice, once in 2007, in order to primarily change references to the Legislative Council to House of Assembly, and second, much more recently, I think shortly after the 12th of March 2021, there was an amendment to the Register of Interest Act 2006, which would have, so as to allow the Registrar of Interest to disclose material to a commission of inquiry. The Act employs, as in force at the moment, imposes a number of obligations on members, and that extends to not just to elected members of the House of Assembly, but also the Attorney General and the Speaker. And primary amongst those obligations is the need to make a declaration of their interests on the date that they assume the functions of their office, and then on each subsequent anniversary of that date. The declaration has to be made in a prescribed form that is annexed or scheduled to the Act itself, and it covers a range of categories where information has to be provided. There is within the Act what may be described as a mechanism by which the compliance of members with that obligation is monitored and remedied if necessary and sanctioned. And so there is a standing committee charged with consideration of matters relating to the register, to which the registrar acts as the clerk. The registrar can submit reports in certain circumstances to that committee, and similarly, in certain defined circumstances, the committee can send a report to the House of Assembly. In some situation where there has been perhaps what might be described as severe default, the House of Assembly has powers of sanction on an individual member. The third area of interest I would highlight is the obligation on a minister attending cabinet to declare a conflict of interest. And you may remember that when Minister Vincent Wheatley gave evidence to you, he said something about that. The detail is in the Cabinet Handbook 2009, which you've heard evidence of, and from, for example, the Cabinet Secretary Sandra Ward. But briefly, that sets out the obligations on a minister or someone otherwise attending cabinet to declare an interest or the interest of a member of the family in a matter which is before cabinet and before that matter is disclosed. The interest can be private, pecuniary, or non-pecuniary. It means that once declared, the person must not participate in any further discussion. And where a minister or a member of cabinet has doubts or uncertainty over their interest in a matter, then the Cabinet Handbook prescribes that they should inform the Premier in advance of the matter coming up for discussion. And that's all I propose to say on the legal framework. Perhaps before we call our first witness, if I could just reiterate that the purpose of this session is to obtain further evidence and information from those who are subject to the system, make use of the system, in order, as you indicated earlier, to see how the system works. And that will involve asking questions of individual about their interests and how they go about declaring those in accordance with the requirements imposed on them.
Yes, thank you, Mr. Rowell.
Mr. Commissioner, our first witness is the learned Attorney General Dawn J. Smith. If I could ask that the Attorney General is sworn now.
Yes, thank you.
Good morning, Attorney General.
Good
Would
morning.
you like to swear an oath or make an affirmation?
I'd like to affirm, please.
Okay. I think somewhere under. Would you like to take the sheet and repeat the words in front of you?
Thank you. I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you.
Good, thank you, Attorney. Yes.
Good morning, Attorney.
Good morning.
Can I first of all start off by thank you for coming to give evidence to the Commission today and deal, as I do with every witness, with the formalities. So can I ask that you give the Commissioner your full name, please?
Yes, my name is Dawn Juliana Smith.
And your professional address?
TTT Building, Rotown, Tortola, Virgin Islands.
As I say to all witnesses, and I'm not sure whether it helps, but my questions are intended to be short and simple. But if at any time you have any difficulty understanding a question or you would like me to repeat it or put it in a different way, please do ask me. There are a number of bundles in front of you. We don't need to look at them now, but we will be going to them, or some of them, in due course. I'm sure I don't need to tell you this, but can I ask that you do keep your voice up, speak slowly. As you'll appreciate, it's important that your answers are accurately and clearly recorded on the transcript. Can I begin by asking you just to give the Commissioner a short summary of your professional background before you assumed the position of Attorney General to the British Virgin Islands?
A short summary of a long life. Okay. Well, I qualified as a barrister of the Eastern Caribbean Supreme Court in the Virgin Islands in October 1997. From then, I was in private practice until I think August 2006. When I was appointed as the representative of the government of the Virgin Islands in Europe, and I was based in London for 3 years. After that, I returned to private practice. And in January 2013, I joined the Financial Services Commission as their general counsel. And I stayed there. Well, while I was there, shortly after Hurricane Irma, I was seconded to the Premier's office as permanent secretary from November 2017 until February 2019. I left my position as general counsel at the commission to take up the post of Attorney General, which I've held since the 1st of October 2020.
Thank you very much.
Thank you. If we go to the first bundle, there should be a bundle that is your witness bundle.
Yes.
If you could go, please, Attorney, to page 21 in that bundle.
Yes.
If I've taken you to the right page, it's a letter that you wrote to the Commission dated the 2nd of June 2021.
Yes, it is.
And I wanted just to draw your attention to the third paragraph of that letter, because there you explain that the position of Attorney General of the Virgin Islands is a public rather than political office.
Yes.
And you were appointed after a competitive application process.
Yes.
And your appointment is made by the Governor on the advice of the Judicial and Legal Services Commission.
Yes,
And as I understand it, that commission is chaired by the Chief Justice.
yes,
And there is also a judge of the Court of Appeal or the High Court present on that panel.
yes,
And so one difference between the Virgin Islands and England and Wales is that appointment as Attorney General does not follow from membership of a particular political party.
no, it doesn't.
I just, you as attorney, and tell me if I'm wrong in this, but you play and have played a role in piloting through the House of Assembly the more recent amendments that have been made to the Register of Interests Act of 2006.
Yes,
And am I right to say that the pending legislation, which is the Register of Interest Bill 2021, is a piece of legislation that would be drafted by your chambers?
it is being drafted by my chambers, yes.
And does it then follow that you would be responsible for taking that piece of legislation through the House of Assembly?
Not necessarily, I may. I took through the Register of Interest Amendment Act, so it is likely that I would take that one as well.
And I think as of the 3rd of June, the Register of Interest Bill has yet to reach the House. Is that right?
That's correct.
And that's still the position at the moment.
That's correct.
And I can take you to it if you need to see it. But one of the changes that it will make, if passed into law, is that it will make the Register of Interest public or available for public inspection.
You can take me to it.
If we go to the bundle, please. You should have, should be a Constitution and Legislation bundle.
Yes.
You should find the bill at page 82 in that bundle.
Yes, I have it.
That's the first page. I'm sorry, yes. So if we turn to 83, that will be then the first substantive page of the bill. I know it's headed Register of Interest Act, but I'm calling it, I hope rightly, a bill at the moment. If you go through to 86, please. This is part of clause 5 of the bill, but if I draw your attention on page 86 to 5.3, it says the registrar shall permit inspection of the register at the request of any member of the public during normal working hours. And that's what I have taken to mean that obviously this has yet to become law, but if it does become law and that clause is maintained, then the effect is that a member of the public can come along and look at the or inspect the register.
That's correct.
On the 4th of May, when you first made submissions to the Commissioner, one of the points you made about the role of attorney was that good governance or maintaining good governance is your mission statement.
Yes, it is part of my mission statement. Yes.
And whilst others may be critical of it, as attorney, you do occupy a unique role within the Constitution.
I do.
You are an independent law officer who advises the Cabinet, the House of Assembly, and the Governor.
Yes.
Your yes was said with some hesitation. If you wish to add to that, please do so.
No, no.
Given your role, you may feel that you can't answer this question, but if you can, it would be helpful. Do you think that if the register as intended is made available to the public, that is something that would promote transparency and accountability and so be beneficial to good governance?
You're asking for my opinion.
Yes, as the Attorney General.
I think if the register is made available to the public, they may be able to say whether it is correct or not.
And can you help us with this then? Would that, in what way do you think that that may assist in promoting good governance, if at all?
We haven't defined good governance. Is there a definition that you wanted me to use, or you just wanted me to?
No, I'm not going to put words in your mouth, attorney, but I link back to it being part of your mission statement, and so that it's your own sense of good governance, if you like. I mean, if we it is not easy, I accept, to define good governance or sometimes bad governance, but it's perhaps if I drop the phrase good governance and talk about accountability and transparency, does putting the public in the position where they can say whether something is right or wrong about the register, does that, in your view as attorney, promote accountability and transparency?
It would.
Can I take you to your own register of interests
Yes.
account? And I'm going to put this in context. If I explain it, what I'd like to do is to use that, because you're our first witness, as a bit of an example. And so I may ask you again about your view and your opinion as attorney about the obligations that the Register of Interests Act impose. If you go, and this is in your own bundle, to 6, please.
To page 6?
Yes, please.
Yes, I have it.
For the transcript, it's a letter that was addressed to you as a member of the House of Assembly. It's dated the 19th of February 2021. And it refers to the Register of Interests Act. And if you go to page 7, attorney, one of the matters that the Commissioner asked of you, and let's put it in context, what request 1 was the date and content of each declaration of interest that you have made at any time during your tenure as a member. And we have to appreciate that in your case, your tenure as a member is still relatively short.
Yes.
You have yet to complete 1 year as Attorney General. But then at 2, the Commissioner asked, irrespective of any such declarations you may have made, the information and documents that you would provide in such a declaration of interest, if made now pursuant to Section 3.1. Section 3.1 is the provision in the 2006 Act that imposes that obligation on members to make a declaration to the registrar. Now, if you go to page 10, please. This was, attorney, a letter from you dated the 12th of March, in which you responded substantively to the 19th of February 2021 letter. I'm not going to read out the detail that you set out in that letter, but if I draw your attention to your point 3, it's right, isn't it, that what you did was to set out using the categories in Schedule 1 to the Act, which we will come back to. You set out those interests that you would declare on the register as of that date. That's right, isn't it?
Yes.
So would you accept that there is nothing under the 2006 Act that prohibits a member of the House of Assembly from giving information such as you gave to a third party?
I may give the same information to a third party in another context. Whether I would, and I don't know if this is the question you're asking, but whether I would give the declaration that I gave to the registrar to a third party in the form that I gave it to her, the answer to that is no. And my reason is that I understand that what I gave to the registrar at this point in time to be a confidential document. The information that is written in section 3, I would have had to disclose, for example, as a public officer or some portion of it.
But if I understand your answer correctly, if you had completed the form and then delivered it to the Registrar of Interests, on your view of the operation of the Act, that document is not something that you can then give to a third party. But you are at liberty, as a member of the House of Assembly, to set out the information that you gave to the registrar and give that information to a third party.
For another purpose,
Yes.
I may have to, yes.
Yes. And well, what the Commissioner was seeking from, I'm sorry, please to go ahead.
Yes, but what I wouldn't do is to purport to go against the intention of the Act by making my actual declaration available to a third party.
I think we're at the same point.
Yes.
But and the point to make is that the request was seeking voluntary information, and you felt able to volunteer that information. Mike, if I move on then?
I'm sorry, could I just ask one question here? I understand that difference. So really, you say there's no confidence in the information. It's your information, you can give it to whomever you like. In terms of the form which you sent to the registrar for a declaration, the information is yours, that's confidential to you, but why would you feel any difficulty in making that public? Because isn't the confidence in you? You have the right, the confidentiality right, don't you?
Is the question, why would I have a difficulty in making the information public?
No, because you said there's no problem with making the information public, but you said there was a problem making the document that you sent to the registrar public.
Yes.
Why is that?
I would respect the scheme, the statutory scheme.
But isn't the statutory scheme to respect your confidentiality?
The statutory scheme provides for me to provide information in a particular form to the registrar.
Yes.
And for that information to be kept confidential by the registrar, as well as the documentation that I provided to her.
But isn't the confidentiality yours? Or who's the beneficiary of the confidentiality? The confidence that is being protected is your right to.
That may be so, but I should respect the law.
Okay. Yes, thank you.
The Register of Interests Act 2006, which is the present law, requires a member of the House Assembly to provide a declaration of interest on the date they assume office.
Yes.
And so in your case, it's the 1st of October 2020.
Yes.
They are then required to do that on every subsequent anniversary. So for you, the next declaration falls due on the 1st of October 2021.
Yes.
Now, I can take you to it if you need me to, Attorney, but the Act provides that if a member does not provide a declaration within 3 months of the date on which it's due, then that amounts to a breach.
Yes.
And it doesn't provide a defense of reasonable excuse, does it?
You can take me to that section.
Yes, please. If we go, do you still have it open in front of you?
Yes, I do. Well, I thought I did.
Let me take you to it again. It's the register of interests you'll find at page 59. And if we go to section 7,
Just give me 1 minute, please. Okay, what page did you say it was?
the Act starts at page 59. And if we go to page 64 and section 7, if you need me to take you back to section 3, by the way, Attorney, do tell me, but section 7A reads as follows. Where a member fails to make a declaration within a period of 3 months from the date on which the duty to make that declaration accrued, the member shall be in breach of the provisions of this Act, and the registrar shall, within 14 days of the knowledge of such brief, submit a report of such breach to the committee, which shall meet to consider the report within 21 days of its submission. And so it seems on its face that the mechanism of the Act provides that you have to make your declaration on the due date.
Yes.
If you haven't within 3 months, you have committed a breach.
Yes.
And that then leads to a report being written and it's sent to the committee. And that's the standing committee charged with considering the register of interest.
Yes.
And my question was that when one reads the Act, it doesn't provide any defense to that. You either come within the 3 months or you don't.
Yes, that's correct.
And if you don't, then the risk is that sanctions may ultimately follow.
That's correct.
Now, the committee that I've been referring to is, as I've said, described as the Standing Select Committee of the House of Assembly, charged for the time being with the consideration of matters relating to the register. Now, that's its full title as per the Act. You'll find that at page 60, Attorney, if you need it.
Yes.
As of today, is there a Standing Select Committee in place? Do you know, Attorney?
I believe that there is.
And when was it established?
I don't know. I don't believe I was there at the time. But I believe that one is currently in existence.
And you assumed office, obviously, on the 1st of October 2020,
yes.
Taking that as the date. From that date, can you say whether it was in place?
I believe it is in place. I don't have personal knowledge of it. I'm not a member of it. So I can't tell you what I don't know. I believe that the committee is in place, yes.
But you can't say when it was established for this session?
I don't have that information, no.
You say that you're not a member, so you've not been asked at any point to give any kind of advice to this Standing Select Committee during your tenure as Attorney General?
No.
Do you know who chairs the Standing Select Committee?
I don't know, but I believe that it is the Premier, but I really do not know.
Do you know who the members of the Standing Select Committee are?
I do not know.
The Act allows a registrar to submit a report to the Standing Select Committee. It allows the Standing Committee to also refer a matter to the House of Assembly.
Yes.
Now, keeping it to your time as Attorney General, which I accept is brief, but in that time, have you ever learned that a report was submitted to the Standing Select Committee?
No.
Have you ever become aware of the Standing Select Committee referring a matter to the House of Assembly?
No.
Tell me if you cannot answer this, but obviously in earlier pre-2019 sessions of the House of Assembly, there may have been a Standing Select Committee. Have you learnt that in previous years, the Standing Select Committee was established or not?
I believe it was. I have not verified it. I have not checked. I wouldn't want to say so with any certainty because I myself have not seen the documents, have not verified the point, but I believe that one existed.
And again, this may be something that you cannot help us with, I accept that, but pre-2019, insofar as you know, did the Registrar ever submit any reports to the Standing Select Committee?
I don't know.
We are inevitably jumping between bundles, but not too many at present. If we go back to your own witness bundle, please, Attorney, on page 46. This is the form that you've submitted to the registrar, and I'd like to just take you through some of it. I don't want to go into the details that you have provided. What my questions would, I hope, seek to elicit from you is your understanding as to what is required on the form. To deal with the details that you gave briefly, Attorney, if you look at page, well, but if we set it into this context so that those who are following can perhaps better understand, the form is scheduled to the Act. And it has a preamble that explains the main purpose of the Register of Interests. Perhaps if I could read that, Commissioner, into the record.
Yes, okay.
The main purpose of the Register of Interests is to provide information of any pecuniary interest or other material benefit which a member receives, which might reasonably be thought by others to influence his or her actions, speeches, or votes in the House of Assembly, or actions taken in his or her capacity as a member. For details of the information which is required to be registered, please refer first to the explanatory notes in each section of the form. The preamble continues by saying that if there is a need, additional sheets can be attached to the form, and each such sheet should carry the member's signature. And if there are any changes or additions to the entry, they should be notified to the registrar within 1 month of any changes occurring. If I pause there, Attorney, would I be right to understand the scheme this way? You submit your form on the appointed date, in your case, the 1st of October 2020. You know that 1 year later you will have to do the same. But if in between there is a change to your circumstances, which could be a positive or a negative change, it is incumbent upon the member to return to the registrar and provide that additional information. Is that right?
That is my understanding, yes.
And the reason for that is that that maximizes the opportunity to maintain an accurate and up-to-date record.
I would say so, yes.
Now, in your case, and again, taking it shortly, if you look at, if I do it this way, what happens next is that the form has 10 categories, and we'll look at them in due course. But what it requires is that the person completing it give details under each category, and each category comes with explanatory notes that is meant to, I suppose, give guidance. Would you accept that?
Yes.
Now, in your case, dealing with your own form briefly before returning to the categories, you gave under directorships details of 2 unremunerated property holdings.
Yes.
That's at page 47. You then, at page 54, under the category that deals with the land, you set out details of 2 undeveloped pieces of land in Martin Springott and a residential property.
Yes.
And then if I take you to page 55, under shareholdings, you disclose shareholdings in a property company.
Yes.
Now, taking those 3 entries together, they appear to refer to the same pieces of land, if you like, the same properties. If I give you an example, if you compare 47 and 55, you've explained that in relation to a property company, you are a director, and then you've also made clear that you hold shares in it.
Yes.
My question is intended to be a general one, attorney, but it's that the approach that you have adopted, which is of putting, perhaps might be said to the same information under different categories, raises the possibility that if a form like this is completed diligently, then the same information may be needed to be given more than once.
Yes.
Because the same interests could trigger different categories, couldn't it? You could be both a director and a shareholder.
Yes, that's true.
Or you could be a director and your spouse could be the shareholder.
I didn't have to address my mind to that issue.
No, I'm speaking again generally rather than your own specific circumstances. Okay. But it's the point that if it's completed diligently, you may be giving the same information more than once.
Yes, that's possible.
And that approach is necessary, isn't it? Because one of the functions that falls on the registrar's shoulders is to ensure that it is an accurate record. And so as much information as the registrar has, the better they're able to perform that function. Would you agree?
The more accurate information the registrar has, yes.
Yes, the registrar has to be satisfied that the record is complete and accurate.
I believe that is one of her responsibilities under the legislation.
Can I take you just please to the different categories? And again, it's general questions. It's not about your own disclosure. If we go to 37, it's category 1, which is directorships.
37 or
47,
47?
I'm sorry. Thank you.
Okay, good. Mm-hmm.
Notes, there are 2 notes, but note 1 says you should include directorships which are individually unremunerated, but where remuneration is paid through another company in the same group. Could you just, for the record, explain what you consider that note is directed towards?
Could you repeat that question, please?
I've read out note 1,
Mm-hmm.
and it's that, as well as what I'd put to you is that what the guidance that is being given to the person filling in the form is that, as well as disclosing a directorship that is individually unremunerated, so that you're not receiving payment directly from that company, but if you are receiving remuneration through another company in the same group, then that must be disclosed.
Yes, that's what it says.
Would you accept that as a interpretation of that note?
I believe that's what it says, yes.
If we go to category 2,
This is on page 48.
48, please. Yes. That is for remunerated employment from a job or office, trade, profession or vocation, apart from membership in the House of Assembly or ministerial office. So obviously, as a public officer, you fell outside that. But that is intended to allow the member to declare any other activities that they may be engaged in, be it business or a separate job. That's right, isn't it?
Yes.
If we go then to category 3 on page 49, what that says is, does any of the paid employment registered in categories 1 and 2 entail the provision to clients of services which depend essentially upon or arise out of your position as a member of the House of Assembly? And it then directs the person completing the form to note 1, which reads, the services covered by this category include actions connected with any parliamentary proceeding, sponsoring meetings or functions in the House of Assembly building or offices, making representation to ministers, fellow members or public servants, accompanying delegations to ministers, and the provision of advice on parliamentary and public affairs. And so would I be right to say that what category 3 is intended to elicit is circumstances where either because you have a directorship or you, through your employment, your remunerated employment, you provide a benefit to a client which arises out of being a House of Assembly. So for example, you make representations on behalf of a company in which you have a directorship. That's what's required to be declared, isn't it?
Yes.
Because that is something that, even with the register not being public, is something that is important for transparency purposes. Because if members of the House of Assembly are making representations on behalf of individuals or businesses with which they have a connection, it's important that that be recorded. Would you agree?
It is important, yes.
If I look at now to category 4, which is headed sponsorship. The first question that's put to the person filling the form is, did you benefit from sponsorship before election where, to your knowledge, the financial support in any case exceeded in aggregate $2,500? And note 2 says you should register money given to you by your election campaign committee and money spent by your election campaign committee in connection with your election with your permission.
Where are you reading from, please?
Sorry,
yes, I see it now. It's at the bottom of page 50. Yes, okay.
And there's also a qualification which is perhaps now out of date, in that it doesn't apply to elections that took place before the enactment of the 2006 Act, which was in 2008. So in relation to this paragraph 4A, what do you understand is meant by sponsorship?
That's an interesting question, having never run for election myself. I suppose it has to do with whether you have a sponsor.
Can I suggest that if
place before elections, that's what I'm assuming it means. Did you benefit from any sponsorship before election? Where, to your knowledge, the financial support?
But if we look at note 2, where it refers to election campaign committee and money spent by your election campaign committee.
Yes.
Isn't it wider than that, in that if money is spent on if you are given money for your campaign or money spent on your behalf for your campaign, then it is
would
important
include
that you
yes.
declare that.
It is included, and yes, you would have to declare it.
If I briefly take you, Attorney, to B, 4B, do you benefit from any other form of sponsorship or financial or material support as a member of the House of Assembly? And the relevant note here seems to be at note 1, where it says you should register under this section any financial or material benefit, direct or indirect, for example, the provision of free or subsidized accommodation or provision of the services of a research assistant or at a subsidized salary rate. And so again, it's about declaring potential interests here. So if you receive, let's say, if a member of the House of Assembly were to receive free office accommodation from which to conduct their business as an elected representative, that is something that should be included in this part of the form, isn't it?
It would appear so, yes.
I'm sorry, Mr. Rowd. All of these are, on the face of it, personal benefits. So sponsorship before the election, as it were, money you get to fund your election campaign.
Yes.
Similarly for B, when you are a member of the House of Assembly. Is there any regulation of political funding more generally? I mean, for example, party political funding. Is there any regulation of that? That's taking us outside the scope of your of the registration of interests.
Outside of this,
Yeah, outside of registration of interests.
not that I'm aware of, but I haven't myself checked that.
Okay.
Yes,
Thank you. That's fair.
but I don't believe that there is.
Attorney, I will skip through a number of categories because I don't have questions for them on you, but I just want to sort of just, again, for those following the hearing remotely, just so that they see this. Category 5 is gifts, benefits and hospitality for Virgin Islands. So that is in relation to gifts that you receive whilst in the Virgin Islands. Category 6 deals with overseas visits, where the cost of the visit was not wholly borne by the member or by public funds. Category 7 is overseas benefits and gifts. Category 8 is land, and what it refers to is the need to declare is of any land other than any home used solely for the personal residential purposes of you or your family. And so the member isn't obliged to declare their home if they use it solely for residential purposes. If they were used to use it for an ancillary purpose or to have other property interests, those would have to be set out at this part of the form. Would you agree?
Yes.
And then if we go to category 9, which is at 55, that's shareholders. And what's required is each company or body indicating the nature of the business and the extent of the interest. That takes us to category 10, which is on your page 56, Attorney. It is headed miscellaneous, and it reads as follows. If bearing in mind the definition of purpose set out in the introduction to this form, you have any relevant interests which you consider should be disclosed, but which do not fall within the 9 categories set out above, please list them. And for the record, you wrote none at this point, but again, my question is more general, and it is this. What do you understand to be the purpose of category 10?
Right, so that would take me back to the introductory paragraph. And what it would be getting at is whether, notwithstanding the 9 items listed, if there is any interest or material benefit that would not be covered by the 9 questions preceding number 10, and a member would reasonably think or reasonably be thought by others, it would reasonably be thought by others to influence the actions of the member, their speeches or votes in the House of Assembly, or their actions taken as a member, then it ought to be written in that section.
And so when completing that section, what the member has to do, doesn't he or she, is to consider whether they do have any other interest which could be thought by others as potentially influencing their actions as a member of the House of Assembly. So put simply, they have to think, what would others think about me if they learnt about this information?
Yes, they do.
And about my conduct as a member of the House of Assembly?
Yes, they do.
Can I briefly now just take you back to the law bundle and to the Constitution and legislation bundle that we looked at? It's 65 that I'd like to take you to. Oops, hang on, if you give me a moment, please, Attorney. Sorry, if I take you to 79, first of all. This is the amending statute, the Register of Interest Amendment Act 2021, which you introduced into the House of Assembly. And it amended the Section 9 of the Principal Act, the 2006 Act, and it did it in two ways. Firstly, that it allowed, if you need to look it up, Dan, you'll find Section 9 at page 65.
Yes.
But it widened the circumstances in which the register could be open for inspection beyond a criminal investigation or the order of a court, but to include upon the written request of a commission of inquiry.
Yes.
The amendment also introduced was an amendment to Section 13 of the Principal Act, which we find at page 67. The amendment we find at page 81.
Hold on, you said 67?
67 is the original Section 13.
Yes.
If you look at 80, we'll see the text that is being introduced by the 2021 Act.
13, yes.
And the substantive amendment was that where a request for information is made to the registrar pursuant to Section 1B, then the registrar may provide information that in his opinion is strictly necessary to fulfill the request, and upon such conditions as to the preservation of confidentiality after the purpose for same has been exhausted as he shall deem appropriate. Now, that provision, is it directed at a commission of inquiry or also at a court?
If I can have 1 minute, please.
Of course.
I'm just reviewing. Your question is, who is that section directed to?
Yes.
Well, the section is directed to the registrar. And she can impose those conditions, as I see it, on anyone who is able under the Act to request that information from her.
See, so those that are presently able to request information are firstly someone conducting a criminal investigation.
Yes.
Secondly, a court
Yes.
conducting legal proceedings. Thirdly, now a commission of inquiry, and fourthly, a member making a written request.
Yes.
Now, your view of the amendment is that, at least in relation to it, applies beyond the commission of inquiry. It could apply to a court as well.
Yes.
But ultimately, whether conditions are imposed is a matter for the registrar exercising a discretion under the Act.
Yes.
And we've dealt with this, I think, in a previous hearing, but in terms of subsection 1A, the new subsection, conditions can be imposed by the registrar, but only as to the preservation of confidentiality after the purpose for the disclosure has been exhausted. So, I mean, take a court proceedings. She can only impose conditions once, as it were, the court proceedings are over.
That's the way I understand it. Yes.
And that you explained, or someone on your behalf explained at a previous hearing.
Yes.
Yes.
You've told us that the new bill, which will, in fact, if it comes into force, will repeal the 2006 Act and create a new scheme for the Register of Interests, that it has not yet been put before the House of Assembly. When then does the opportunity arise for members to seek amendments to the bill?
Could you repeat that question?
The pending bill
Yeah.
is the Register of Interests Bill 2021. That, on your evidence, has not yet been introduced into the House of Assembly.
I don't even know that it has gone to cabinet.
Right,
Right.
I see.
I believe it's still in the drafting stage.
Thank you for that clarification. Now, so the first step is for it to go to cabinet.
Yes, it will go to cabinet.
And at that stage, can cabinet seek amendments of the bill?
A cabinet may make recommendations as to amendments to the bill. Yes.
The bill is then introduced into the House of Assembly.
Yes.
And is it at that stage that members can seek further amendments to the bill?
Yes.
In your experience as Attorney General, have you ever received representations on a bill when it's at the drafting stage and still effectively within the control of your chambers?
Representations
From members or cabinet ministers?
I couldn't say, because a lot of that drafting, I wouldn't do it myself. Do we receive representations on bills that are being drafted? Yes, we do. They can come from various quarters, and it also depends on what type of consultation happens. Depending on the type of bill it is, there may be consultation before the drafting begins. There might be consultation with select groups while it is happening. There may be consultation within the public service. So even in the course of drafting, you may receive recommendations or suggestions as to what ought to be included and so on. Have I ever received, or should I say, has Chambers ever received any from members of the House of Assembly during my tenure? I don't believe so, but I couldn't say yes or no, but I just don't believe so.
If I could turn to another matter, please. As attorney, you sit as an ex officio member of the cabinet.
Yes.
You will recall that at the beginning, before starting my questioning of you, I set out some policy in relation to ministers and members of cabinet's obligations to declare a potential interest. Now, I don't need to ask you specifically about whether that obligation has ever fallen on your shoulders, attorney, but I wanted to ask you this. As attorney sitting in cabinet, have you ever been called upon to advise as to a potential conflict of interest?
No, members typically disclose them themselves.
The cabinet handbook, which I referred to, says that where a member has some uncertainty or doubt over an interest, then they should speak to the Premier. Do you, in your view as attorney, is the question, or if there were such uncertainty, is that something on which you would be able to advise in principle?
Is the question, should I advise or can I?
Can you advise? The handbook provides for someone to go to the Premier if they have uncertainty or doubt. Is it also possible for them to go to the Attorney General?
Well, it's fairly typical for people to come to the Attorney General if they have uncertainty or doubt on any matter which they think has a legal implication. So I would say yes.
Thank you. So may I just have a few moments? Commissioner, those are all my questions. Can I conclude by once again thanking the Attorney General for coming to give evidence to the Commission today, and also for the way in which she has done so. Thank you.
No, can I add my thanks to those, Attorney? Thank you for coming and giving your evidence and giving it so clearly. Thank
You're
you very
very
much.
welcome, Commissioner. Thank you.
Now, Mr. Rawat, two things. Firstly, I suspect before the next witness, we'll have to take some COVID steps to make sure that the desk is clear and so on. But how many other witnesses have you got today? I'm just looking at the time. And
we have. We will be calling the Honourable Sharie B de Castro, the Honourable Shereen Flax-Charles. I think then we have the Honourable Kai Reimer and the Honourable Carvin Malone. I note the time, and you may want to have a short break now.
Yeah, this is very difficult, but how long do you think you'll be with the next member?
I don't know whether that will be a comfort to the Honourable de Castro, but probably longer than I was with the learned Attorney General.
Right. Given the work we've still got to come, can I suggest that we now break until, say, 1:30, and then we'll carry on with Honourable Sharie B de Castro? Yes?
Thank you.
Good. Thank you all very much. Good. Are we ready to resume?
We are, Commissioner. Our next witness is the Honourable Sharie B de Castro.
Good. Thank you.
Good afternoon. Would you like to swear an oath or make an affirmation? Could you take the Bible in your right hand and read what's written on that piece of paper there, please?
I swear by Almighty God that the evidence I shall give shall be the truth and the whole truth and nothing but the truth.
Good. Thank you very much. Just one moment. Thank you. Mr. Howarth.
Thank you, Commissioner. Mr. Castro, thank you for coming to give evidence today. And can I apologise that we've kept you waiting for some time? Could we start off, please, with the formalities? Could you give the Commissioner your full name, please?
Commissioner, my name is Sharie B de Castro.
And your professional address?
My professional address is Richard Stout Building, Rotong Tortola, Virgin Islands.
Thank you. I hope to try and keep my questions short and simple. If at any time you have difficulty understanding a question or you'd like me to repeat it or rephrase it, please do ask me to do so. There are in front of you a number of bundles. We may need to go and look at some of those documents in due course, but for the present, we can keep them shut. The final thing to remind you of is, and this is just to ask you to please keep your voice up. Please speak slowly. It's important that your answers are clearly and accurately recorded on the transcript of this hearing. Can we start, as we did with the Attorney General, just by asking you to give a brief summary of your background, your professional background before you entered politics, please?
Yes, Commissioner, I am an educator by training. So I was a teacher at the Elmore Stout High School here in the British Virgin Islands. And I am also the owner of an educational business, Right to Read, which focuses on literacy advancement.
And it's right, isn't it, that you were selected as an at-large candidate for the Virgin Islands Party in the 2015 election?
Yes, Commissioner.
But you were unsuccessful in that election.
That is right.
But you stood again in the 2019 election, and that was again as a territorial candidate for the Virgin Islands Party.
Yes, that is correct.
And can you help us with this, please? Is it right that in order to stand for your party as a territorial candidate, you would have to be nominated by the party?
Yes, that is correct.
And again, the way the territorial seats work is that the Virgin Islands are one single constituency. And is it that the top four candidates with the top four votes are the ones that get the seats?
Yes, that is correct.
At the time of the 2019 election, can you remember what the population of the BVI was?
I cannot remember specifically what the population was, but I believe, given the voter registration, I believe it was about around 15,000 voters. I believe the population would have been anywhere from about 35,000, but I stand to be corrected.
Appreciate, obviously, I'm asking you to cast your mind back in time, but in terms of those eligible to vote, it's about 15,000.
Yes, that is based on my recollection. So.
Yes. I think, and we can check this, but I think that there is on the government website, the official results are published, and what those record for the 2019 elections are that there were 15,038 registered voters and 9,720 ballots cast. Now, again, can you help us with this? Is it right that if a voter in that election would be able to vote for the representative in their district, but also then be able to vote for 4 people to sit as a territorial representative?
Yes, that is correct.
So one person has in effect 5 votes?
Yes, that is correct.
How many votes did you get yourself?
I can't, Commissioner, I cannot remember the specific number. I know that it was above 4,000 votes, but I do not remember the specific details of like the exact number. But I know it was, from my recollection, it was above 4,000 votes.
I think again, the official records recorded as 4,778, which was 12.49% of the votes cast for territorial candidates. Would that accord with your recollection?
Yes, that is correct.
And I think, but again, I probably stand to be correct on this, but I think you were top of the list in terms of votes cast. You got the first seat, if you like. Is that right?
Yes, that is correct.
And once elected, you were appointed as Junior Minister for Trade and Economic Development.
Yes.
But then subsequently, a few months later, you became the Junior Minister for Tourism.
Yes, that is correct.
And you're still in that role, are you not?
Yes, sir.
Now, I believe Mr. Castro were here in the room when I was asking questions of the learned Attorney General. I was asking her about the Register of Interest Bill of 2021, which, as the Attorney explained, hasn't yet reached Cabinet or the House of Assembly, but it is something that has been discussed publicly. One potential effect of that bill is that it will make the Register of Interest public, and so a member of the public can come along and look at it. Is that a measure that you are in support of?
Commissioner, I am in support of the Register of Interest being made public. To further clarify, currently, the Integrity and Public Life Act is before the House of Assembly this week for its second and third reading. And subsequently, it does suggest changes or amendments to the Register of Interest Act. So it is my understanding that it will be amended forthwith.
I see. That is something new to us. So the integrity bill, if you like, will also make changes to the Register of Interest Act of 2006.
Yes, sir. That is my understanding.
And are those changes that the Register of Interest, the current Register of Interest, will become public? Is that one of the changes that's envisaged?
Yes, that is my understanding.
And without putting words into your mouth, Mr. Castro, is one of the reasons that you would support that, the register being public, is that it makes or promotes government being seen as accountable and transparent.
I believe that is correct.
Could we look then at the declarations that you've had to make as a member of the House of Assembly? Now, you assumed office, obviously following your success at the polls, on the 12th of March 2019. Is that right?
Yes, that is correct.
And as the Attorney General explained to the Commission this morning, under the Register of Interest Act of 2006, you are then required to provide a declaration of your interests on that date, the 12th of March 2019, and then on every subsequent anniversary. Do you accept that that's an obligation that's on you? If we go, please, to, you should have I hope your bundle in front of you. If you go to 74 in the bundle. This is, excuse me. So this is, I would suggest, the first declaration that you made. And you can see at the top, it's stamped, and the date, it's stamped Registrar of Interest, Government of the Virgin Islands, and written in manuscript inside the stamp is the date 10th July 2019. If you go to the last page in the bundle, you'll see the last page of the declaration, which is 84. And this is the last page, and that is, if I ask you, can you confirm that that's your signature, Mr. Castro?
Yes, it is.
And it's dated the 10th of July 2019.
Yes, it is.
Now, would you accept that you did not file your declaration on the required date, the 12th of March 2019.
Yes, I accept that.
And in fact, it seems that you were out by 4 months. Is that right?
That is correct.
Now, the attorney explained this morning that what the Act does, and if you need me to show you the Act, please do say so. What the Act does is that it gives you 3 months after the date to submit your declaration. And if you haven't done so within 3 months of that date, the Act says you are in breach, and the registrar can write a report. So would you accept that by being 4 months out from your date, you were in fact in breach of the Register of Interest Act 2006?
I do, and permit me to explain that as a newly elected member of the government, it was a steep learning curve, and without formal orientation to the position. Subsequently, I was, through the notifications from the registrar in reminding me, I subsequently did take due consideration to visit her office to be fully informed and briefed as to what is expected of me. And on that date, I did fill out my declaration and submitted it.
Could I break that down a little with you, please?
No problem, sir.
You've explained that as a newly elected member, you have a steep learning curve. So and you refer to orientation. Who's responsible for giving you the orientation?
In general, my assumption would be, as a newly elected member, that the House of Assembly would have, in some form or fashion, introduced workshops to members to familiarize them with the processes and structures and responsibilities therein. And that was not the case. So I was, as a new member, being newly accustomed to the role, basically adjusting to this new responsibility. After becoming fully aware of what was expected of me, I did subsequently submit the Register of Interest declaration.
Were there any members of your party who had been elected to the House of Assembly in 2019 who had previously been members of the House of Assembly?
Yes, that is correct. There is.
How many?
There was one member that was previously elected.
And
every other member was new. The sole member that was elected previously was the Premier and Minister of Finance, the Honorable Andrew Foy.
And correct me if I'm wrong, but is the Premier also would be the leader of your party in the House of Assembly? Would that be right?
Yes, the Premier is the leader of the party.
And did the Premier speak to yourself and other newly elected members about the importance of completing the Register of Interest declaration?
I cannot specifically remember if that was the case. However, I did state previously that my expectation, becoming a new member in any position, in any organization, that I would generally be oriented to the role by the persons in charge of said organization or department. And as stated, and which I know is customary in other islands within the Caribbean and other jurisdictions, there are new member workshops that do take place that enlighten members as to their roles and responsibilities. I'm simply suggesting and stating that that was not the case when I was elected.
But to repeat the question, who do you say is responsible for giving you that orientation?
I believe that as new members, the House of Assembly itself, in terms of the staff, the office of the House of Assembly, should give an orientation process to members newly elected so that they are fully aware of the processes involved as sitting as a member of the House.
In response to a question from me, the attorney earlier today said and confirmed that the Act doesn't give you a defense of reasonable excuse.
So I am not in any way giving you an excuse. All I did was stated my position as to why my Register of Interest declaration was late. I have admitted that it was late and I stand by that. However, I was simply giving you an explanation, being a new member to the House, why that was the case from my position.
And just so that we can be clear, in the first few months that you were a new member, no one in the House of Assembly gave you any orientation which included the importance of filling in the register of interest?
So there was no orientation. I can say that the only correspondence I received in reference to the register of interest was from the register of interest, where she stated that I should comply with producing a declaration and the subsequent letters that she wrote reminding me of doing such.
Do you still, how soon after your taking up your position as the newly elected member, did the registrar write to you?
I cannot remember the specific date at this time.
Do you
Well,
have...
I believe that there's I'm sorry. I believe there was a letter dated for the said date, the 12th of March, 2019, but I would have to revert and actually check that.
Do you have that correspondence with the registrar?
I would have it. I don't have it on me now, but it is something that I should be able to produce.
You've referred to the registrar sending you letters. Did you respond to her?
I didn't respond in writing, but I did have phone conversation with her to basically set up an appointment to meet with her in order, because she did give that opportunity that we could reach out to her if we had any questions concerning the register of interest. And so I did take that offer and I met with her in person at her office and subsequently filled out the form on said date.
So being fair to the registrar, is it right that on or about the date when your declaration was due, she had written to you to remind you of your obligation?
I believe that is the case, yes.
So
I would have to produce the documents stating the specific date.
So from that date, March 2019, you were aware that you had an obligation to fill in the form?
Yes, that is the case.
And did you, when you became aware of that form, go and look at the act and say, what is it that I need to do?
I do not remember specifically when I did comply with that. As explained earlier, being a new member, I can state at the time it was quite busy in terms of adjusting, but I can state that when I actually did meet with the registrar subsequently, I filled out the form and it was submitted.
Were you aware, Mr. Castro, that you could be reported to the standing committee charged with considering the register of interest?
At the time, no.
When did you become aware that you could be reported to the standing committee?
I became aware sometime after. I cannot specifically state the date, but it wasn't before I submitted my initial declaration. It was sometime recent.
Sometime recently?
Yes.
Well, how recent? Can you help us?
I would say within the last few months.
In 2021?
Yes, in 2021. I had not subsequently known that there was a provision that stated that it was within 3 months.
Does that mean that it's only in 2021 that you have become aware that there is a standing select committee charged with considering the register of interests?
No, sir, that is not the case. I'm aware that there was a standing select committee established for the register of interest. I'm not certain of the specific date. I believe it could have been sometime in the latter part of 2019. And that was done through a motion, I believe, in the House of Assembly, appointing members to said committee.
And would you be able to give the Commissioner the date on which that motion was passed?
I would have to find that information, but I can present it.
Do you know who chairs the committee?
Yes, I know who chairs the committee. The Honorable Premier chairs the Register of Interest Subcommittee.
And who is on that committee?
The members of the committee, based on my recollection, are the Honorable Neville Smith, the Honorable Kai Reimer, the Honorable Shereen Flax-Charles, and the Honorable Marlon Penn.
Could you turn to page 63 in your bundle, please? This is the second declaration that you provided to the Registrar of Interest. It's your 2020 declaration. So as you've confirmed, it fell due on the 12th of March 2020. We can see this is the first page. It is stamped the 12th of May 2020. And if you go to the last page, which is at your page 73, please. Again, can you confirm that that is your signature on that last page?
Yes, that is my signature.
And you dated it the 12th of May 2020.
Yes,
So it would seem that on the day you completed the form, that was the day it was before the Registrar of Interest. Is that
Yes,
right?
that is correct.
But it's also right that, again, you haven't submitted it by the required date, did you?
That is correct.
It's within the 3 months, but it's still not on the required date.
It is within the 3 months and not on the required date, but I will expound by stating that at that time, the territory was on a lockdown and there was interruptions in in normal business as it relates to offices being opened. Subsequently, given the time that we were in, upon being able to do so, I did submit my register of interest.
Was the territory on a lockdown on the 12th of March 2020?
I cannot specifically remember the exact date. I know that the territory did go into lockdown in March, but I'm not sure of the specific date.
Were you aware of the obligation in the Act that, as well as producing a declaration every year, if there were changes during the course of that year, you had to draw those to the attention of the registrar?
Yes, I was made aware of that.
Was there correspondence in 2020 between you and the registrar over your second failure to provide the declaration in time?
I am not particularly sure. That is something that I can check, given the time that we were in. I do remember the correspondence from 2019, but I cannot specifically state about 2020. I believe I would have gotten a letter stating that it is due on the 12th of March, but subsequent correspondence, I am not certain.
And again, I appreciate that you want to check what correspondence you have. But is it likely that you would have retained those letters from the registrar?
Sorry, can you please repeat?
You've indicated to the Commissioner that you will need to check what correspondence you have.
Yes.
But is it likely that you have retained the letters from the registrar?
Yes, that is very likely. It is something that I can submit at a later date.
If we go just to look, please, at, so that you can orientate yourself around the bundle, Mr. Castro. If you look at WB, your witness bundle at 52. This is your most recent declaration, because again, you would have had a declaration that falls due on the 12th of March 2021. If you see that it's there, again, we see the stamp of the Registrar of Interest written in manuscript on that is the date 11th of May 2021. If you go, however, to the last page in that document, which is at 62, again, just for the record, can you confirm that that bears your signature?
Yes, it does.
But it's dated the 12th of March 2021, so that is the due date.
That is correct.
Can you assist the Commissioner with the discrepancy between those two dates?
Yes, I can. We received a notice from the registrar, as usual, a written letter stating that our interest would be due. They will be upcoming on the 12th of May. Sorry, on the 12th of March, my apologies. However, at the time, the Registrar of Interest, we were also notified that by the clerk of the House of Assembly that the Registrar of Interest was ill and was hospitalized. And so we were unable to submit the said documents. However, they were sitting there waiting to be submitted. Upon return to the office, she wrote a letter notifying us that she had returned, and that was the said date that it was submitted.
So she had given you guidance, complete the form, leave them with the clerk of the House of Assembly, and then when she was well again, she would review the forms.
Well, just to clarify, not to leave with the clerk, they were filled out and left in my office, and my secretary did submit upon receiving the letter stating that the registrar was back in office.
So on this third year, you were in date, so to speak. That's right, isn't it?
That is correct.
It might be suggested to the commissioner in due course that your failure to file on time 2 years in a row is indicative of someone who's taking a relaxed view to their obligations as a member of the House of Assembly. Would you accept that?
I would not accept that.
And why wouldn't you accept it, please?
I believe I have prefaced my explanation in the past as it relates to what my position was upon entering office and subsequently. So while I accept that I was late, I will not accept that it was due to me being somewhat, I forgot the word that you used.
The word I used was relaxed, but you can use your own words if you wish.
Yes, so no, I just wanted to quote you directly. I do not submit to the fact that I was being relaxed in doing so. I believe that I wanted to ensure that given the series of events and also maturing in the seat at the House of Assembly, having gained and acquired the subsequent knowledge, that I wanted to make sure that I was in line with what was required of me.
You explained that in relation to the 2019 declaration, you had received no orientation.
Yes.
You had received a letter on the 12th of March 2019 from the registrar notifying you of your obligation to file a declaration. You did so, as we've seen, in July 2019.
Yeah.
In 2019, did you make any representations that there was a need for orientation?
Yes, I have been making representations that there was a need for orientation, and it was further cemented by my subsequent participation in the Commonwealth Parliamentary Association programs and seminars through the region and internationally. Subsequently, I was also a guest speaker at 2 or more new member parliamentary proceedings for the Anguilla House of Assembly and the Grenada House of Assembly. So that is why previously I referenced that it is customary that when a new House of Assembly is installed, that it is practiced through the region, that perhaps through the Commonwealth Parliamentary Association, or even potentially just through the House of Assembly of that specific land, that there are new member workshops so that members could be apprised of their responsibility. I can state, as referenced, I believe previously, that in fact, 2.5 years later, today is in fact the first workshop from the Commonwealth Parliamentary Association for new members in the British Virgin Islands House of Assembly. That is unfortunate, but it is the case.
The question was directed to whether you had made those representations in 2019. Did you make representations?
I stated that I did, and I did subsequently. I just further explained my knowledge as to why I did, having interacted with other parliaments and their new member orientations.
If we look at page 7 now, please. If I've taken you to the right place, you should have a letter dated the 19th of February 2021.
Yes.
And it's a letter addressed to you from the Commissioner. And it relates to obligations under the Register of Interest Act of 2006. And it's a request for information. And if we go over to the next page, the Commissioner asked you 3 things, and I will summarize them. Firstly, the date and content of each declaration of interest you've made during your time as a member. Secondly, irrespective of any such declarations, the information and documents that you would provide in such a declaration if it was made at the date of the letter. And thirdly, if during your period of appointment as a member, you failed at any time to comply with your obligation to make such a declaration, in respect of each such failure, a full explanation as to why you did not make such declaration and what, if any, sanction, admonition, direction, or adverse consequence resulted. Now, in response to that, you sent 2 letters, and I want to take you to both of them. The first one is at page 10. You'll see there, Mr. Castro, that you acknowledged the receipt of the letter, and that was on the 17th of March 2021. The Commissioner had asked for a reply by the 26th of February 2021. But on the same day, you also sent a more detailed letter, and that's dated the 17th of March as well. And in response to the Commissioner, you made a number of points. You said, as a member of the House of Assembly, and since the introduction of the Register of Interest Act 2006, I've complied with Section 3 of same in the form and manner as set out in Schedule 1 therein. You then write, I do not keep copies of my declaration of interest, and as such, I will not be in a position to assist you with the dates and its contents. And then you refer to the change that was made by the House of Assembly, the amendment passed to the Register of Interest, which allowed the Commissioner to obtain information from the Registrar. Now, you make only one reference to dates, and you say that you're not in a position to assist with the dates of the declarations. Does that mean that as of the 17th of March 2021, you'd forgotten that you twice failed to submit your declarations on time?
That is not the case. I just did not know the specific date as requested.
Was there any reason why you could not have told the Commissioner at that time that you were aware that you had failed to submit them on time?
I do not believe that that is the case.
So there was no reason you could have volunteered that information at that time?
I believe so. However, given the fact that we had taken the initiative to go into the House of Assembly and amend the said legislation, I believe that the Commissioner had direct access to retrieving such documents.
Can I ask you, so why do you not keep copies of your declaration of interest?
At the time, I cannot answer as to why that was the case. However, given my maturity in it, I have since realized that it would make sense to do so. And by so doing, I may have been able to give the dates. However, I would not have been inclined to give the specific documents that I submitted.
Would you have been inclined to give the information that you submitted?
My understanding of the said letter was that the documents, and I reference the particular instruction. Give me 1 minute.
Page 8.
Yes, it referenced the documents, and my understanding was that the documents could not be given, and subsequently, because of the amendment to the law, it was my understanding that the documents would be available. Thereby, the Commission would have access to those documents.
Well, my question is really directed to point 2 of the Commissioner's letter, which actually seeks the information that you would give. So it's asking you for your own information.
Please clarify, you said number 2?
Yes, no, on page 8 is the 3 requests that the Commissioner made of you on the 19th of February 2021. Number 2 of which is the information and documents that you would provide in such a declaration. So the Commissioner wasn't asking for the form itself, but for the information.
Well, it says information and documents. So I looked at it collectively. If you are stating now that the information could have been submitted void of the actual document and declaration, perhaps that could be considered. But at the time, my understanding was that the documents were to be submitted.
Now, the Commissioner sent the same letter to all members of the House of Assembly, and he received replies from other members of the House, which were in very similar terms to your own. Did you discuss the content of your response with other members of the House of Assembly?
Can you please clarify your question?
Of course. If I take you back to page 11.
Sure.
And so, and that's your fuller letter.
Yes.
You have that?
Yes.
Thank you. The 19th of February letter that we were just looking at
Yes.
was sent to all members of the House of Assembly.
Yes, sir.
Seeking the same information.
Yes.
The Commissioner received different replies from different people.
Okay.
But there were a group of members of the House of Assembly who sent letters, the wording of which was very similar, if not the same, as your own letter.
Okay.
And so my question is, before you sent this letter, did you discuss its contents and what your response would be with other members of the House of Assembly?
Thank you for your clarification. Based on it, I can now answer. I did discuss with the members of my government the letter that was requested of us, and we did collectively draft a template that we subsequently submitted, personalizing it to our individual interest. Or if you need clarity, I could explain, but that's.
Well, perhaps if I could break it down with you, please. The letter, I mean, when one looks at these letters, the wording, the substance is exactly the same.
So I did just not to interrupt you, but I did just confirm that there was a correspondence between members of the government side in relation to the request. And subsequently, we did draft a template. Hence, it would be the case that there are similar dynamics within the letter, perhaps identical in many cases. So I have not negated from assuring you that that was the case.
I'm not suggesting that at all, Mr. Castro. What I was trying to do was just to break down your evidence a little bit.
Okay.
And the point is that what you're saying is that this letter, yours is dated the 17th of March, 2021, was the collective work of the members of the government side of the House of Assembly. Is that right?
Yes, in ensuring that we meet the requirement to answer to the Commission of Inquiry as requested.
Mr. De Castro, I have no problem with that as a principle, but drafting a template is fine as long as you can all sign up to it.
I'm sorry? As long
as you can all sign up to what the template says.
Yes.
But in paragraph A of your letter, it says, I have complied with section 3 of the Act, and you hadn't.
Okay, in reference to the one time that I was out of.
Well,
the specific time as outlined.
Twice you've been outside time, once in breach. So you hadn't complied with section 3.
Okay, so in that case, I do take note of that.
So as I said, nothing wrong with it.
My statement in that regard was based on the fact that I had submitted in reference to breaking it down further as it relates to the deadlines and the due dates. That was not considered based on my submission. However, I do understand your point.
Yes, thank you.
In together drafting this letter, did the discussion involve members of the group raising the fact that they may have missed the deadline for submission of the declaration of interest?
I cannot recall that to be the case.
But leaving aside the position in relation to your own declaration, the other matters that are set out there are ones that you would not have signed the letter. You would concern matters that you would only have signed this letter if you agreed and supported them. So, for example, the reference to the amendment of the Commission of Inquiry of the Register of Interest Act, you wouldn't have signed this letter off if you hadn't agreed it.
Yes, that is the case.
Could we look in a little bit more detail at your own form, please?
Yes.
Now, you have 2 declarations in the bundle. We only need to go to 1 because the information that you've put on both is the same.
Okay.
So if you go to page 52, please. It's the 2021 declaration.
Yes.
And I think I referred erroneously to you having put the same information on 2 forms. In fact, it's the same information on all your forms. So I apologize for that, but we can just take this as the example now. And it's really asking you about your approach to completing this form, please.
Okay.
Because as we explained earlier, one of the things that the Commissioner is interested in is how the system works. Now, when you fill in this form, did you read the preamble to it that we see at page 52?
Yes, I did.
And did you understand what the purpose of it is? Is that it's for you to give information that might be thought by others as possibly influencing your actions or your behavior as a member of the House of Assembly?
Yes.
If you look then at what you completed, there are, as we've looked at, 10 categories in this form. The first category is directorships. And you confirm that you hold no remunerated or unremunerated directorships in any company. And that's right, is it?
That is correct.
If we turn over, you go to the next category you have to complete as a member of the House of Assembly is remunerated employment, office, profession, and et cetera, et cetera. And you tick that as yes, and you wrote down right to read after school literacy company. Now, you explained at the beginning of your evidence that it's an educational company.
Yeah.
Are you an employee of it as a company and it's actually owned and operated by somebody else?
No. So for clarity, I am the sole owner of Right to Read, and I was the sole employee at the time, providing after-school programs for both children and adults who had difficulties with reading specifically. And so I sought to give them the necessary redress to get them up to their reading levels. So I was the sole person in the entity, owner as well as employee.
And as is it a company? I mean, are you a
no,
director?
No, it is not a company. It is not a company. It is a DBA. So I just have a trade license, but it is not a company.
If you turn to category 3, which is then headed clients, and this was canvassed with the Attorney General. And the purpose of category 3 is for you as a member of the House of Assembly to disclose any services that you may have provided to clients. So for example, if on behalf of Right to Read, you had made representations to another minister, that's where you would have had to disclose that. If you had in any other way made representations for a client, then you would have to disclose that as well. Now, in your case, you said no to that, and that's the correct position, isn't it?
Yes, that is correct.
Paragraph category 4, please, and that's sponsorship. Now that breaks down into 2 aspects. The first one is it asks you, did you benefit from any sponsorship before election, where to your knowledge, this financial support in any case exceeded in aggregate $2,500? And there are notes at the bottom. If I draw your attention to note 2, please, Mr. Castro. It says you should register money given to you by your election campaign committee and money spent by your election campaign committee in connection with your election with your permission. Now, focusing just on that aspect, which is elections, what do you understand was meant, or what did you understand was meant by sponsorship?
I understand it was sponsorship during the campaign for the election.
And so obviously we're looking at your 2021 form, but it must relate to your 2019 position as well. Now, you said no to that. So does it follow that you received no funding to assist your campaign?
That's not what was stated. It stated that it did not exceed the amount.
I see. Where, to your knowledge, the financial support in any case exceeded in aggregate $2,500, is that the total level of support or the support from an individual? What did you understand it to be?
Can you clarify your question, please?
Well,
can you repeat it?
I'll take you back to 4A.
Okay.
It asks you, in effect, declare sponsorship before an election, where to your knowledge, the financial support in any case exceeded in aggregate $2,500.
Okay.
Now, what do you take that to mean?
I understand it to mean that if during election a sponsorship exceeded the amount as stated, I would have to state that I did and subsequently list the sponsors that I would have received such funding from.
And that's individual sponsors. If they gave you over 2,500, then you would have to declare that. If they gave you under that, you wouldn't have to declare it. Is that your understanding?
I believe it is.
So if one person gave you $20,000, you would have to declare it, wouldn't you?
Yes, but that was not the case.
If 10 people gave you $2,000, you wouldn't have to declare it.
Can you please give me a moment to
Of course, please do.
I believe that is my understanding at this time based on what you have collated. So I reference, just for clarity, just to make sure that I understand, I reference for clarity where you just referenced in subsection 2, where it states you should register money given by your election campaign committee and money spent. And I specifically referenced that back to A, but because I didn't, sorry, but because I said no to that specific section, there was no need to list in the subsequent section. That is my understanding.
Mr. Castro, the reason for my questions is not in any way to probe what you did or did not declare particularly.
No, that is fine.
What they are directed at is that, you know, as you've explained, you didn't have any orientation. So it's important to understand how you as a member of the House of Assembly approach a form such as this.
I understand.
And what you need, what you feel you need to declare or not to declare.
Okay.
And as I understand your evidence, it is that where you are given sums of money that go over 2,500, then you declare it. If they're below that, you don't declare it.
That is my understanding.
And so your election campaign committee did not spend money on your behalf that went over 2,500.
Just to clarify, in reference to election campaign committee, based on the construct of the party's constitution, the district can assign district committees. However, the at-large representatives do not. It is a collective, given that we do have to work alongside the district representatives. In the case of collective representation, since 5 members would subsequently be the representative for one district. So just to clarify, there's a district committee from districts 1 through 9, but there is not an at-large committee for each single member. Just to clarify, based on what you just read.
Well, that's helpful because you have raised a potential ambiguity in the form, haven't you?
Well, I would say so based on what I have seen.
It's not guidance on your evidence that assists you as a territorial candidate.
Well, no, because based on the construct of my political party, that is not the case.
Well, you may recall that the Commissioner asked the Attorney General this morning about what she knew about campaign finance regulation. You said based on the construct of your political party, there are district committees, but there isn't a committee for territorial candidates. How is the territorial campaign funded?
I would state in very broad terms, I could speak specifically, but generally in the Virgin Islands, and when I say that, I could only speak specific to myself because I cannot speak pertaining to anyone else. But oftentimes campaigns are funded with at the individual's expense. There are some cases where persons do endeavor to give some sponsorships, but holistically, I believe it would be a potential mix of both depending on the member. And to my knowledge, just to answer your initial question, there is no laws as it pertains to campaign financing, to my knowledge.
if we look at the second aspect of category 4, which is benefits that you receive as a member. So it's now once you're in post, if you like, and you're asked, do you benefit from any form of sponsorship or financial or material support as a member of the House of Assembly? And you've answered that no. Is that right?
That is correct.
If we then look at the next few categories, if we go to category 5, which is on page 57, please.
Yes.
It's headed Gifts, Benefits and Hospitality Virgin Islands. The question that is put to the person completing the form is, have you or your spouse, to your knowledge, received any gift of a value greater than $500 or any material advantage of a value greater than 1.5% of the current salary of an elected member of the House of Assembly from any company, organization or person within the Virgin Islands, which in any way relates to your membership of the House of Assembly? Now, again, you've confirmed there by striking out yes, that you have not received gifts, benefits and hospitality during your time as a member of the House of Assembly above $500 or 1.5% of the current salary. Is that right?
That is correct.
In relation to overseas visits, which is category C, you're asked if you or your spouse made any overseas visits arising or related to being a member of the House of Assembly where the cost was not wholly borne by yourself or by public funds, and you've said no to that.
That is correct.
Obviously, circumstances that we are all aware of will have limited the opportunity for you as a member of the House of Assembly to go abroad anyway. But in your time as a member of the House of Assembly, have you had opportunity to make overseas visits?
Yes, I have.
And were those funded out of public funds or by yourself?
They, in relation to my position, if I traveled on official duty?
Yes,
I'm
not asking you about your personal.
Oh yes, on official duty, it was funded by public funds.
Category 7 asks you to declare any overseas benefits and gifts, and you've confirmed there, as you do on your earlier forms, that you have received during your time as a member of the House of Assembly, you have not received overseas benefits and gifts that come within that category.
That is correct. Can I just give a point of clarity as an explanation? In the context of BVI, as I have experienced it, and I'm a newly elected member, but I can state that oftentimes money or funding is requested from us in the case of sponsorship, not so much the other way around. So I wanted to make that clear. If there are initiatives within the community, whether through schools, whether through various groups, persons would make representation, but in reference to, because I see it specifically asking whether we do receive sponsorship. I wouldn't understand the likelihood of that given the construct of how or representation is set up.
See, so we're returning to category 4 here, but in
general, because I realize you're moving on to land next, so I just wanted to make a general statement based on my experience that would be the case.
So your experience is that the sponsorship is the other way around, if anything.
Yes.
Can I come back to that after
if you would like
through this form? The next one is the category that a member of the House of Assembly must fill in is land, and it's land other than any home used solely for the personal residential purposes of you or your family, and you've said no to that. You don't own any land that fits within that category.
That is correct.
And then category 9 is shareholdings. Whether you have shareholdings in any company or body which has a nominal value greater than $25,000 or less than that sum, but greater than 1% of the issued share capital of the company or body. And that, again, you said no to that.
That is correct.
In effect, so outside your responsibilities as a member of the House of Assembly, your only other interest, if you like, is right to read, for which you have a trade license.
Yes.
I'm going to take you just now to ask for your help on category 10, which is miscellaneous. And that's on page 62. If you need to refer to the start of the form again, that you'll find that on page 52. But what category 10 asks you to do is, if bearing in mind the definition of purpose set out in the introduction to this form, you have any relevant interests which you consider should be disclosed, but which do not fall within the 9 categories set out above, please list them. And you have left that blank. So what do you understand the purpose of paragraph of category 10 to be?
Can you give me a minute, please?
Of course.
Okay, so in summary, my understanding is that if there is something that does not fit within the categories that went before, that I should disclose it. If I believe it is, and I would have to go back to page 52, where it speaks to the purpose of the declaration of interest. So the reason I left that blank is because I did not believe that there was anything additionally that I needed to declare.
If you go back to 7, please.
Number 7?
Yes, please. This was the letter of the 19th of February.
Oh, page 7, you mean?
Page 7, please,
Okay,
of course.
my apologies.
We've looked at this already. If we go to page 8, I just want to draw your attention to what the Commissioner in that letter said about the category 10 that we've looked at. The letter records that the Commissioner considers, and in any event requests, that when responding to that paragraph.
Sorry, can you tell me specifically which?
If you go to page 8, please.
Yes.
And you've got 1, 2, and 3.
Okay.
Underneath that, there's reference to paragraph 10 of Schedule 1 of the 2006 Act.
Okay.
And that's what I've been calling category 10.
Okay.
Right? And what the letter says is the Commissioner considers and in any event requests that when responding to that paragraph, you should include any relevant interests of immediate family members and any persons living in the same household. Now, you responded to that letter as we looked at page 11.
Okay.
And you said this, in relation to paragraph 10 of Schedule 1 of the Principal Act of 2006, it does not specifically address interests of immediate family members. However, once again, in the spirit of assisting your Commission in further strengthening good governance, I do propose to recommend to the House of Assembly that such paragraph can be amended to expressly mention the said family members. Given what you've just said as your understanding of this paragraph and what its purpose was, why did you think that it wouldn't already cover interests held by immediate family members?
Okay, just give me a moment. Let me just switch to. Okay, just can you repeat your question? Because I've been able to scan through the said sections.
I'd asked you earlier about your understanding of that last part of the form, number 10. I've drawn your attention to the Commissioner's letter.
Yes.
And to your answer, which was that it did not specifically address interests of immediate family members. But my question is this: given what you have already said was your understanding of the purpose of that last category or paragraph, why do you think, why doesn't it already cover interests of immediate family members?
Okay, 1 minute. Okay, so based on my understanding of your question, in relation to that specific number 10, there were references in the said document that we had to fill out where, and I'm trying to draw my reference to it, where it specifically stated that a spouse or a dependent child. So in those instances, it was specifically stated underneath the said section that in terms of an explanation that it was stating whether spouses or dependent children. So specifically to that number, I did not see such additional notes. So I was not aware that it spoke in any way based on the request that those additional portions were specific to that number, if you understand.
Well, what do you understand, Mr. Castro, by the phrase immediate family members?
I understood immediate family members as per the well, in my general understanding, given that this is what we are dealing with in terms of the declaration of interest, it would have to be what is referred to in the document, which is just your spouse or dependent children.
Accepting that you've left that blank, so I'm not going to ask you about why you left it blank or not, but I'm going to put this to you. Okay. You've agreed, I think, and said that the point of 10 is to disclose any interest that another person might think could influence your actions as a member of the House of Assembly.
Yes.
Now, if, and this is a hypothetical, you had an adult sibling who had a contract with government, shouldn't that be an interest that you might need to put in 10?
Commissioner, you're asking me hypothetically, but based on my understanding of the law, in terms of the register of interests, where it makes specific note of what it means by specific areas of the declaration, as stated before, in areas where they wanted to know about your spouse or your dependent children, it was specifically stated on the form. It was not stated there. So my understanding was that it would have been in reference to spouses and children, and I can submit that I do not have neither. So it would not have applied to me.
I'm sorry, Mr. Rao. If that's right as a construction of the form, that's how you've construed it. That would be a weakness in the system, wouldn't it?
Well, it would be given your line of questioning.
No, yes. So you said that's a weakness in the system, and that's a weakness in the Act, perhaps. But...
Well, I'm not sure whether I could agree that it is a weakness. I have basically perused this document submitted it 3 times, and I believe that I've fully complied with the intention of the form that was given to me.
Oh, I understand that. I understand that. You say you've construed it in this way, and you say that that's the proper construction of the form.
Yes, that is how it is laid out.
That's how it's laid out, and that's what you were required to do.
Yes.
But if that's right, I'm not sure Mr. Rowett agrees, but if your construction is right, it is a defect, isn't it, in the governance system, because the sort of contract that Mr. Rowett has referred to never appears as a declared interest.
Well, I would submit that as of my understanding, it would bring a question to the intention of the declaration of interest. I believe that one can speak to the declarations of their spouse themselves, their spouse and their children. Anything outside of that in the context, that is what I consider to be your immediate family. So in that sense, I would have to request a definition from you as it relates to what you define immediate family as.
But whatever it, however you define it, for the purpose of paragraph 10, your interpretation is that they are not included in paragraph 10. They're only included where, for example, in paragraph 5, have you or your spouse, to your knowledge, received any gift? So in paragraph 10, they're not included.
Well, it doesn't make mention of it, so to my knowledge, no. However, in the larger context of the discussion that we are having, I want to further state that the hypothetical situation that was given was in reference to an adult sibling. However, based on my understanding of immediate family, that would not factor in based on this declaration.
Sorry, I understand that.
Okay.
But forget about definitions. Paragraph 10, any family member, your husband or wife, you say is not included in paragraph 10.
Based on my understanding of the form.
Yes. If that's right, then that is at least a possible deficiency in the scheme, because your husband or wife could have an interest that would fall within the miscellaneous category that is not disclosed. You say properly not disclosed under the system.
It could be if it is the intent for both parties to be included in that miscellaneous category.
Yes.
However, I can only speak based on what is before me.
No, I see that. Yes, thank you.
But the point I was putting to you, Mr. Castro, is wider than the references to immediate family members. The hypothetical I put to you is one that does fall outside immediate family member.
Sorry, can you repeat that?
What I'm going to suggest to you is that if you read paragraph 10 with the preamble, the purpose is for you as the member of the House of Assembly to set out there anything else that can reasonably be thought by others could influence your actions.
I completely understand what you were saying, and you gave me a
The hypothetical that I gave you, and the reason I gave you a hypothetical is because you've left the paragraph blank.
I left the paragraph blank because based on my understanding of the form, it does not pertain to me.
Because it does not refer to.
It does not refer, I can only speak of it as it relates to myself.
I see.
And not only just based on what is expounded in the form in terms of it not specifically stating spouse or dependent children, but because realistically, the only person I can account for is myself, given the current state of individual, as an individual member. I cannot speak as a whole.
But I'm not speaking about I'm not asking questions about your personal circumstances. It's more about what you understand the purpose of the form to be. And as on your understanding of the purpose of the form, its only purpose is to have a declaration of interest that relates to a member, the spouse of a member, and dependent children of a member. So that means that if a member of the House of Assembly does have an adult sibling who has a contract with government, they don't need to put it on this form.
As I've stated before, the register of interest, as I understand it, is specific to a spouse and children. I understand the hypothetical situation that you put forth, but given the construct that it is, I can only speak to the form as it is, and therefore I am unwilling to speak to the hypothetical situation, given that I can only speak based on what is in print in front of me.
Now, what you told the Commissioner in your letter of the 17th of March was that you proposed to recommend to the House of Assembly that the paragraph be amended to expressly mention said family members. Now, have you made such a proposal to the House of Assembly?
I have not done so as of this moment, no.
Do you still intend to make the proposal?
Well, based on the clarification and the potential weakness, again, I state potential weakness, it is something that could be considered in the context that if it is, as with the other sections in the form, that we ought to specifically state whether our interests are in that category pertaining to our spouses or children, then it should be explicitly stated. So that would mean an amendment in the form that we have to fill out.
And now, I told you I would return to the question of sponsorship. as in sponsorship coming from you as a member of the House of Assembly. Now, the Commission has been told of the existence of a fund that allows for assistance grants to be provided to businesses and individuals. As a territorial candidate, do you have access to that fund?
Yes, I do.
Can you explain how the process works? And I'd like if you could just explain how the process works in normal circumstances. I mean, that is circumstances that existed before the pandemic began.
Okay, so as I understand it, the process, there's an application that persons can collect from the House of Assembly that speaks to the district allocation, or in my case, the territorial allocation, and persons have the opportunity based on specific needs as listed on the form that they can apply for assistance from the said fund from an individual member.
Now, you say persons, is that just individuals, or can businesses apply for assistance from the individual, from the member?
In my experience, it has been individuals, even if they do produce documents stating that they do own a business, it is from the individual.
As a territorial representative, how much are you given to allocate each year?
As a territorial representative, the allocation is $150,000 per year.
Now, the first year that you could have allocated those funds was obviously 2019.
Yes,
taking that year, 2019 to 2020, did you distribute the entirety of the fund that you could have done?
Yes, I did.
Now, what guidance or policies are given to you to follow when deciding whether to give an assistant grant to an individual?
So there is a document that was given to each member by the clerk of the House of Assembly, who's a supervisor for the office, that stipulates how funding can be given based on specific requests or categories. So there is a document that stipulates.
And so, the person fills in the form, it comes to you for assessment. You keep in mind the documents that the document that the clerk of the House of Assembly provided you, and then you decide how much should go to that individual. Is that how it works?
That's how it works. I am, based on my experience, persons supply additional documents along with the form to expressly explain the need, whether it is a letter and additional correspondences, and then the said application process, the said application is submitted from the member to up the chain, basically, to the clerk of the House of Assembly, who gives the final consent.
And has the clerk of the House of Assembly ever refused any grant that you've been minded to provide, to give to someone?
At this moment, in terms of refusal, with the general allocation, I cannot, at the moment, I cannot think of it. If I do, I can revert, but at the moment, I cannot think of it. But there is a process, just to explain, there is a process whereby the clerk, if she sees it fit, can do the necessary due diligence to inform a member if their application that they have signed off on is without the confines of what is allowed.
And are you expected as a member to also carry out your own due diligence?
Of course.
You've referred to guidance from the clerk to the House of Assembly. Would you be able to provide a copy of that guidance to the Commissioner?
I believe it is something that I can provide.
And just so that we're clear, obviously, it's always possible that the guidance may have changed from year to year. Would you be able to confirm whether it is the same guidance, or if not, could you provide all copies of the guidance?
I can confirm that it is the same guidance.
What is the maximum that is, as a territorial representative, that you're allowed to pay out to an individual?
Based on my recollection, there is not a maximum. I can revert and verify that, but I do not believe that there is. The structure is more confined to based on the presented need, whether it be potentially medical, educational, financial hardship, and so forth. But from my recollection, as it relates to that specific fund, there is not a stipulation.
Now you said that it's almost always individuals that you pay out to, even if they have businesses.
Okay, so I'll let you finish and then.
Well, it was trying to understand whether there are payments made to businesses as well as individuals.
Okay, so I can clarify, just based on your prompting, I can clarify that there are instances where payments are made to what I consider to be vendors on behalf of said individual. So in that case, it would be written to a vendor, which is a business, or well, yes, in that case, let me say a business, but on behalf of the individual who would have requested the funding.
So your experience is that the applicants are always individuals.
Yes.
The payment may be made to them.
But let me say individuals, potentially schools. So for instance, right now it's graduation time. It's graduation time in the territory. Schools may reach out to elected members requesting that we sponsor trophies, certificates for said students. So in that case, it's not an individual.
I see. So the money can be paid out to individuals who have a specific need. It can be paid out to community organizations or schools who again contact you for what might more properly be described as sponsorship. It isn't, in your experience, usually paid out to a business. Where such payment occurs is where the payment is being made on behalf of an individual applicant. So then you're paying off to a vendor, to use your word. And again, you've said there's no maximum to what can be paid out to an individual. Is that the same across the board? If a school approaches you for funding, is there no maximum to what you can pay out?
To my understanding, no.
Obviously you do your due diligence. The clerk to the House of Assembly can also, in certain circumstances, conduct a due diligence exercise. Is the money ultimately coming from the Ministry of Finance?
Okay, so I'm not particularly knowledgeable of the construct as it relates to the accounting system. As I am aware, I know that the funding is allocated to each member. If I cannot speak to the specifics of how that is structured, I cannot.
See. But just so that we can be clear, if someone approaches you and they need to pay a loan off, you could actually authorize that money be paid to the company to which that loan is owed.
Okay, so let me clarify. I just want to make sure that I understand what you're saying. So I'll further explain. If an individual does submit an application request with the necessary documents, a member can, given due consideration to the request, give a contribution to support that request, whether it be to an individual or to a vendor, given the context of the request.
Is it possible to make a prospective application, so to pay for something in advance of it actually happening?
Not to my knowledge. Can you be more specific, just so I can ensure that I understand?
I want to be careful about being specific, but is there scope within the system for someone to approach you for a sum of money to be paid to them in advance of an event? If, for example, someone needs to take medical treatment, could you give them funding in advance of them taking that treatment?
If I understand your question, that would be the case because the person would have provided the necessary documentation stating that they would be doing an operation, for instance, just in context, and that funding can possibly be given. And there have been instances where someone would produce a bill, which would have meant that it would have happened already.
Are there any prohibitions on who you, as a territorial representative, can give an assistant grant to?
Yes, any elected member cannot give. I do not remember the specific clause within the context of the document. But based on my recollection, you cannot give funding to immediate family as well as persons who work within the said department, which is the House of Assembly.
Now, you referred to immediate family. What is meant by immediate family in this context?
That is a very good question. I do not, based on my recollection, I do not believe that the form specifically expresses the said definition. However, based on my understanding, it would be appropriate for any member to decide what that is. In the construct of my understanding, I tend to not even consider the thought from the perspective that I do not believe that I should, well, not that I don't believe, I do not give any funding to persons that would be considered immediate family members.
Considered by yourself or considered by others?
Considered in the context because of discussions in the House of Assembly, but in informal meetings. My understanding upon entry, let me just put it this way, for clarity, my understanding upon entry as a new member is that you cannot give, again, I can't specifically state what the language is on the document because it's not before me, but that you cannot give to, I don't know if immediate is the word used, but I'll just say family, given that I don't specifically have the form in front of me, stating exactly what the descriptive language is in support of the definition.
But your recollection is that the document doesn't actually have a definition of immediate family on it, guidance that you're expected to use?
Not to my recollection.
And so different members of the House of Assembly could take a different approach to that question?
That is potentially the case, but I can only speak for myself, which I have previously explained.
In your case, if there is a member of family who does have a legitimate need for an assistance grant, rather, they can't come to you because in your view it falls outside what you can do. How does that person then get an assistance grant?
I cannot answer that because I do not, as stated, I am restricted from helping family members. So I believe it is known, I believe it is widely known that this is the case. And so I have never been confronted with a situation where that has even been brought to me.
So, but is there any guidance on what a member of the House of Assembly should do in that situation?
No, there's absolutely no guidance.
Now, you've spoken about sort of schools approaching you as a member of the House of Assembly for sponsorship, for a trophy, etc. Can you use the fund for any other purpose? I mean, if you wanted to hold an event for children at Christmas, can you use the fund for that purpose?
That is the case. Members can do projects within the community based on the needs that they see and the interest that they have nationally in terms of specific, let's say, sub areas, potentially education, youth, that type of stuff. So it can be used for projects within the district, well, more specifically territorially.
And again, is there any guidance given to you as a member of the House of Assembly as to how you should use the fund for such projects?
Specific guidance, can you clarify when you say guidance, you mean
yes, is there
an
any
itemized list stipulating how it is to be facilitated? Is that what you are questioning?
Let me put it this way. What you've told us is you have guidance, written guidance as to the process by which you can give an assistant grant. The guidance does not encompass what should happen if family members want a grant. But you can also use the funding that you get for projects within the community. But what my question is directed to is that in those circumstances, is there any further guidance, either within the document you're provided or otherwise, that helps you decide what projects you will support, or helps you decide how much you will fund a project, or how to assess whether a project is viable, or what you do with the money? Is there any assistance or guidance given to you as a member of the House of Assembly?
It is based on a member's discretion, given the, like I specifically stated, interests. Any member would campaign potentially on specific areas that they deem to be important to the community in terms of needs that could be filled project-wise. So in that instance, members can potentially do a project, whether it's an event or potentially even, well, the scope of project is wide, but as it relates to any detailed document that specifies in its totality, that I have not had sight of such a document.
In terms of you say you have $150,000 a year that you can use for various purposes. So you can use it to support individuals, you can use it for projects on which you were elected. Are you required to publish annually how you have spent the $150,000?
At the moment, no.
Do you think requiring members of the House of Assembly to do something like that would improve public confidence?
My position is that it is public funds, and therefore any publishing of such, I am not against. I believe that it would only assist the process.
Because viewed from the outside, it might be said that the ability of an elected representative to have a fund of money that can be distributed to voters carries with it the risk of undermining public confidence, doesn't it?
That is your opinion.
So I'm sorry.
Is that a hypothetical?
I'm not voicing an opinion.
Okay, so is that a hypothetical representation?
Yes.
Okay, I cannot formally state whether that is the case or not.
Well, how do you guard against
your question?
The allegation that it looks like vote buying?
That is a very straightforward question. My answer to that would be, as previously suggested, that the said disbursements can be publicly noted. I have stated my position that I'm not in any way against such a move. I am just working within the context of what was presented to me once elected.
Mr. Castro, that's understandable. I understand that. But I think Mr. Rowett's question is this. $1.8 million, that's 13 times $150,000 each year, goes to elected representatives of the House for distribution, as you said, based on the member's discretion, I think was the phrase you used. And there doesn't seem to be any checks and balances on how it is used. Publication would be a check on it, but at the moment, not much in terms of checks. Or what checks are there?
Well, in terms of checks and balances, as per my understanding, the accounts team and the clerk of the House of Assembly would inspect the request and decide whether it is prudent that it moves forward. So as stated before, given the scope of what is required, even if a member does forward an application, it is within the remit of the office that if it does not fall within the current construct of what is expected, that it can be denied.
Thank you. Yes.
Just moving on to another question, please. According to the Constitution, the 2007 Constitution, an elected member of the House of Assembly is required to vacate his or her seat if that member is a director or manager of a company that is contracted to do business with the government unless they've been exempted by the House of Assembly under section 67(7) of the Act of the Constitution. Now, my question is this: have you yourself been exempted from vacating your seat under section 67?
Okay, can you repeat the question?
The 2007 Constitution provides that an elected member of the House of Assembly has to vacate his or her seat if that member is a director or manager of a company that's contracted to business with the government, unless they are exempted by the House of Assembly. And the House of Assembly can make that exemption under the Constitution, and specifically it's under 67(7) of the Constitution.
Okay.
So that then allows the member to continue in the House of Assembly. My question is this: have you had or been exempted from vacating your seat under section 67?
Not at all. I do not have any contracts with government.
Would you agree with this, that to increase trust in the system and to remove the risk of corrupt practices, legislation that institutes policies for candidate and party financing and the registration of political parties for financial reporting purposes can only be a benefit?
I do agree with that.
So in broad terms, Ms. Castro, you would be in favour of openness about party financing, particularly in relation to campaigns?
I believe so. I believe the ultimate aim is to ensure that we have accountable means by which an elected member can be held accountable to the persons of whom they represent. And so to the extent of what that looks like, I am willing to oblige myself to those requests, given that I was indeed elected by the people, and I believe that I should be held accountable to them.
May I have a moment, please?
Certainly, yes. Thank you.
Commissioner, those are my questions. Can I conclude by thanking Mr. Castro for...
Can I just ask a question myself?
Yes, yes. Go ahead.
Commissioner, if I may, I would like to lend some clarity to a previous point that I made.
Yes, go ahead.
Okay, just for further clarity in relation to the checks and balances that are provided as it relates to the funding, there are further checks and balances as it relates to once the application goes through further steps in the process. Ultimately, the application is sent to the Treasury, where it can at that point also be rejected and sent back, given any peculiarities that may arise based on the Accountant General or the staff at the Treasury, because the process basically moves from the clerk of the House of Assembly onto the Treasury Department, where checks are actually issued and signed off on by the Accountant General. So there is a further step where that accountability mechanism is in place, where if there is any additional inquiries, it can be represented at that time.
So the application moves from the member to the House of Assembly clerk?
Yeah, she's the accounting officer for the House.
And then from there on to the Ministry of Finance, and they sign off.
Specifically, yes, the Treasury is under the Ministry of Finance, but specifically the Treasury Department.
And the application goes all the way along?
All paperwork, all PO that would have been published, everything is attached and sent.
Yeah, okay, thank you very much.
Okay. Yes. Could I ask a couple of questions that arises out of that last answer, please? The first is this, is that, is there at that stage when it gets to the Treasury Department, is there a threshold for the sums that they would inquire into? And if for example, you as the member of House of Assembly have approved an assistant grant for a relatively small amount of money, it's gone to the clerk of the House, it then has to go to the Treasury Department to be paid out. Are there sums that would be deemed as so small that they don't need to be reviewed?
No, not, when you say reviewed, what do you mean?
Well, what you've said is that the third check is that the Treasury Department will look at it and may raise concerns if necessary.
Okay, so based on your explanation, there, to my understanding, there is no minimum by which a person can receive. If I understand your question, that's
So
what I believe.
there's no minimum sum below, or there's no threshold below which the Treasury Department will just simply sign the check and not bother to carry out a due diligence exercise.
No matter the amount, the Treasury has the ability and the remit to look through every application as given and thereby make a decision.
In your time as a member of the House of Assembly, have you ever had the Treasury turn down a grant that you have approved?
I have not had that. That has not been the case for me.
I mean, the Treasury would look at it in terms of due diligence in the paperwork that's there. And they have to have an involvement because they effectively sign whatever check has got to be signed. So that's their involvement. So they would look at it from an accounting point of view.
Of course, because all the documents that we would have received are attached to the document.
Yes. Thank you.
Commissioner, as I indicated, I've finished my questions. And what I wanted to do was, first of all, to thank Mr. Castro for coming to give evidence and for the way in which she has given her evidence. It perhaps may help if I just remind her of what she has agreed to go and check.
Yes,
on.
thank you. Yes.
The first is whether she still has the correspondence that she received from the Registrar of Interest, and in particular the letters, the reminder letters that the Registrar sent to her on an annual basis. Secondly,
Sorry, not to cut you. Should I take note or will you?
Well, Mr.
provide a
Olympitus
document?
will take notes. Thank you.
Okay, thank you.
Secondly, I'd asked Mr. Castro the question as to whether, where she has approved an assistance grant, the clerk to the House has refused it, and she said that she would check that. The third is that which is another matter that Mr. Castro wanted to check, was whether there was a maximum to the limit that can be paid out. But that may be encompassed by the fourth matter that she's agreed to assist you on, sir, and that is providing the guidance that is issued to her as a member of the House of Assembly when dealing with grants out of the fund.
And I think Mr. Castro said that she would be able to produce the correspondence with the registrar.
Yes.
Yes. And the guidance.
Yes. So other than that, I've nothing further.
Good, thank you.
Okay. May I just have a minute? I'm grateful to Mr. King. The other matter that Mr. Castro agreed to assist us with is a copy of the motion of the House of Assembly establishing the Standing Select Committee.
Yes.
But again, thank you very much for your time.
No problem. Thank you for having me.
No, thank you, Mr. Castro. Thank you for your time. Thank you for the evidence you've given and the way you've given it very clearly. And yes, thank you for coming.
Thank you.
Now, Mr. Rowett, shall I suggest we have a break for 5 minutes and then the room can be sort of reconstituted, and then we'll come back and hear the evidence of Miss Flax-Charles.
Thank you very much.
Thank you. Yes, I think we're ready, Mr. Wright. Thank you.
Thank you, Commissioner. Our next witness is the Honourable Shereen Flax-Charles. May I ask that Mrs. Flax-Charles be sworn, please?
Yes, thank you.
Good afternoon. Would you like to swear an oath or Bible? Can you take the Bible in your right hand, please? And read what's written on that piece of paper.
I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you.
Yes, thank you very much. Yes, Mr. Roberts.
Good afternoon, Mrs. Flax-Charles. Can I ask you to begin by giving the Commissioner your full name, please?
Shereen D. Flax-Charles.
And your professional address?
Richard Stout Building, Rowtown, Tortola.
As I've indicated to other witnesses, I do try and keep my questions short and simple. It doesn't always work, but if at any time you have difficulty understanding the question I've put to you, or you'd like me to repeat it or put it in a different way, please do ask me. There are a number of bundles in front of you, and we will go to them as necessary in due course. I don't think this will be a problem for us, but can I remind you, as we do all witnesses, just to speak slowly, keep your voice up. And that's because so that we can accurately and clearly record what you have to say. Again, if I could start off by asking you just to give a summary of your professional background before you entered politics, please.
Yes, Commissioner, I worked with the British Virgin Islands Tourist Board in a number of capacities for 20 years, the last being Special Projects Manager.
And is it right that for the 2019 election, you were selected as an at-large candidate standing for the Virgin Islands Party?
Yes, Commissioner.
And was that the first time that you had stood for election, Mrs. Flax-Charles?
Yes, Commissioner.
Now, the official results record that you received 4,033 votes, which is 10.54% of all the votes cast for territorial candidates. Does that accord with your recollection of your success at the polls?
Yes, Commissioner.
And that once you were elected, it's right, isn't it? You were appointed as Junior Minister for Tourism.
Yes, Commissioner.
But subsequently, you've changed roles with Ms. De Castro, and you've become the Junior Minister for Trade and Economic Development.
Yes, Commissioner.
And you're still in that role at present?
Yes, I am.
Now, one of the questions that I've asked others, and I'd like to put to you, is this. There are measures in place to make the Register of Interest public. I canvassed that with the attorney earlier today, who confirmed that that's in the Register of Interest Bill 21, which hasn't yet come before the House. Ms. De Castro, the Honourable Ms. De Castro explained that her understanding is there are actually measures being considered by the House at present. In terms of the measure of making the Register of Interest public, is that a measure that you will be supporting?
Yes, Commissioner, I will be supporting. I'm all for full disclosure.
Could I just take you then to the disclosure that you have been obliged to provide under the Register of Interest Act 2006? Now, in your case, Mrs. Flax-Charles, you also assumed office as an elected member on the 12th of March 2019. And that means that under the Act, you have an obligation to make a declaration on that date and on every subsequent anniversary. That's right, isn't it?
Yes, Commissioner.
Could I just show you your first declaration, please? Before I do, can I just take you to page 35 in the bundle? Sorry, give me a moment, please. Go to page 25. Sorry. This is an extract from the Island Sun newspaper for the 9th of February 2019. And it records, amongst others, your own declaration of interest. Do you have that, Mrs. Flax-Charles?
Yes, I do, Commissioner.
And what we see is that what you placed, and you did it 2 weeks running, was you placed an advert that said, I, Shereen Flax-Charles, would like to declare the following business interests as a candidate in the next general election. Verding Gordon Music School, Anva Productions, Mystic Virgin, EcoBuild BVI, and Flax VI Limited. Now, none of those interests, and correct me if I'm wrong, none of those interests had a contract with government at that time, did they?
No, none of those interests had a contract, Commissioner.
And so would it be fair to you to say that what you were doing was volunteering additional information about your business interests ahead of the election?
Yes, I would say that that is the case.
If we now look, and that's an obligation that's on every election candidate, isn't it?
As far as I am aware, I believe that that is the case.
If we look at page 82, the same bundle, we're now looking at the register of interest. So this is your 2019 declaration. It's stamped with the Registrar of Interest, Government of the Virgin Islands stamp, but in manuscript is the date 8th of July 2019. Do you have that?
Yes, I do, Commissioner.
If you go to the last page in this form, and it's page 92, we see a signature. Could you confirm that that is your signature?
That is my signature, Commissioner.
And you've dated it July 8th, 2019.
Yes, I did, Commissioner.
Now, the obligation on you was to file this by the 12th of March, 2019. So would you accept that you were out by 4 months?
Yes, I do accept that, Commissioner.
Now, one of the requirements that's placed on a member of the House of Assembly making the declaration is to set out their interest as of the date that it's due. So if it's the 12th of March, as in your case, the obligation is to set out your interest as of the 12th of March. Now, when you filled in the form in July 2019, were you declaring the interest you held in March 2019, or were you declaring the interest you held in July 2019?
It would have been when I declared in February in the newspaper, Commissioner.
So you were just repeating what you had put in your February declaration?
Basically, there was one company which was the only company which would have been Flax VI Limited, Commissioner, that is not included.
Mrs. Flax-Charles, can I just slow you down a little bit? I'd like to take it in stages, if I may, so that we can understand how you came to fill in the form. The purpose of the question is to understand two things from you. Firstly, how the system works, and secondly, how you as a member of the House of Assembly approach the completing of this form and the making of declarations. Now, my question was this. I'll come back to the detail that you provided to the registrar in a moment, but there are two obligations, and this came from the Attorney General, that a House of Assembly member faces. The first is to submit the form on the due date and to give their interests that they have at that point in time. The second is, if at any point their interests change, is during the year to update the register. And the purpose is to have an up-to-date register at all times. Now, you were 4 months late. So were you supplying the information as to your interest? It may be the same information, things may not have changed, but when you, was your understanding that you had to give the information about your interests that was contemporaneous as in July 2019, or were you thinking, I've got to tell them what interests I held in March 2019?
Well, my understanding, Commissioner, was I needed to submit the declaration to the newspaper 2 weeks before nomination day. And on March the 12th, if I recall, that is the day that we were sworn in. I do not remember when I received that letter from the registrar. And I'm sure it is probably around that date. And yes, I was negligent in getting it in on time, and I do accept that fact.
The Act doesn't allow for a defense of reasonable excuse. The difficulty it presents for members of the House of Assembly is that if 3 months have expired after the date that is due, then they are held to be in breach of the Act. So in your situation, because you are now 4 months after the 12th of March, you were in breach of the Act. And is that something that you accept?
Yes, I do, Commissioner.
Now, you explained just a moment ago you can't recall receiving correspondence from the registrar.
No, I said on that particular date or before that. I know that I did receive correspondence. I'm just not sure of the date. I would have to look back in the bundle to see where that information is.
Right. When you, so 12th of March 2019, you're sworn. That's the date on which you're obliged to complete the form. Is your evidence that you can't remember receiving a letter before that date, but you do remember receiving letters after that date?
I do not recall if I received it before that date.
Now, can you remember how soon after you were sworn that you received correspondence from the registrar?
I would have to check the documents, Commissioner. I'm not 100% sure. I don't want to give a date and then it is the wrong date.
Now, you say you'll have to check the documents. The Commission hasn't obtained copies of any correspondence between yourself and the registrar. Do you have copies of that?
Those I can provide for you, Commissioner.
You've accepted that at least in this first time round, you had breached the Act, but were you aware at the time that you could be reported to the Standing Committee charged with considering the Register of Interests?
No, I was not, Commissioner.
Now, the Honourable De Castro has told the Commissioner that I think you're a member of that Standing Committee, is that right?
Yes, I am, Commissioner.
When were you appointed to the Standing Committee?
It was sometime in late 2019, I believe. I would have to check back on that as well.
And when you say late 2019, was that around the time that members of the House of Assembly were allocated to committees?
I believe so, Commissioner.
Well, if you could provide the Commissioner with the date at which you were first appointed to the committee, that would be helpful. And is that the date at which the committee was first constituted?
I would believe so. I believe that is the case, sir.
Again, the Honourable De Castro has told us who else sits on it. So as I understand it, it's chaired by the Honourable Premier.
That is correct, Commissioner.
I think, is it yourself and Marlon Penn also sit on the committee? And any other members of the committee?
Honourable Kai Reimer and Honourable Neville Smith.
Since you were appointed to the committee, how often has it sat?
The committee has never sat, Commissioner, since I was appointed.
And in the time that you've been a member of the committee, has it received any reports from the registrar?
That I would not know, sir.
So you've never been asked to deal with any business concerning the committee for considering the register of interest?
No, Commissioner.
Can we go back to your first declaration, please? Now, this is your 2019 declaration. I can take you back to what you put in the notice, the election notice, if you need it. But you've put, and this is at page 83, Mrs. Flax-Charles, you've put reference to Flax VI Limited. If you go over the next page.
Page 81.
81. Okay, right.
It's my page 81.
If you give me a moment, I'll just check whether it's also my page 81. No, it's my page 83. So
I think it's Miss Flax-Charles's page 81, but she's got it.
Right, I do have it, and it is there, so I would have to redact that statement I made earlier. I did not realize, Commissioner, that the directorship, as opposed to the DBAs, I have them separate.
Okay.
Perhaps we can get into that detail as we go through. And what I've tried to remember is the difference in page numbers so we don't all get lost. But at your 81, it's your 2019 form, and you've referred to Flax VI Limited. On the next page, when you get to paragraph 2 of the form, you then set out that you mention the Island Silhouettes Boutique, the Naughty Virgin Beach Teak Boutique, Virgin Gorda Music School, and Eco Build BVI, which you say is construction, contractor, landscaping, interior decoration. Now, what you did not mention was Anva Productions in this form. Was there any reason you omitted Anva Productions?
I cannot say at this time. I would have to go back and check. Some of the businesses may not have been active at the time of that the form was filled.
So, and the reason I ask, of course, is in February 2019, in your election notice, you'd made reference to Anva Productions. So,
right.
Was Anva Productions active in July 2019?
I am not sure. I will have to go back and check.
Obviously,
Anva Productions, let me explain, Commissioner, is a music studio. And due to the destruction caused by Hurricanes Irma and Maria, the studio was completely destroyed. So while we might have kept the license going, nothing was happening in terms of any recording.
I see. If it was an active business, would it come under directorships for you, or would it come under remunerated employment?
It would be a DBA, and it would be, for me, it's unremunerated, as it is a business that my husband deals with directly.
What you also didn't refer, which you did mention in your 9th of February 2019 election notice, you didn't mention in your declaration Mystic Virgin. Was there any reason you omitted Mystic Virgin from the declaration of interest?
That too was not in operation at the time of this declaration.
Had it been in operation in February 2019?
It was.
Could you just explain the reference to the 2 boutiques? I can probably guess the business, but what role do you play in those businesses?
Right now, I do not play a role. My husband deals with those businesses exclusively. Even when I was working at the tourist board, the workload is a lot. And so I have not been able to pay attention to those businesses. And further, so when I was elected, I averaged 18 to 20 hours a day, 7 days a week. And so I had absolutely no time to deal with those businesses.
Are they businesses in which you have a shareholding or that you co-own?
Those are DBAs. And if I recall, all of those are in my husband's name.
We may come back to the detail in a little while.
Yeah, I might be
of your DBAs.
Right.
So I think there is a document that you produce with your declaration, which I can take you to. But I just want to take you to your second declaration, which is at my page 66. So it may be at your page 64.
It is 66, so there we are.
Thank you. So this is the declaration for (2020). Mrs. Flax-Charles, do you have the document?
Yes, I do, Commissioner.
And so what we see again on the first page is that it's stamped again with the registrar stamped, written in manuscript as the date 2nd of June 2020. And if you go to page 76, that's the last page, with the exception of the annex that you attach. And it's again, it is right, it's signed by you.
And it's my page 74, sir.
Right. Just confirm it's your signature.
It is my signature, Commissioner.
And it's dated the 26th of May 2020.
I see that.
So again, is it right that in that year you had not submitted your declaration by the required date, which was the 12th of March 2020?
That is correct.
Now, you've said you'll check for the correspondence that you had in 2019 with the Registrar of Interest. Do you remember having correspondence with her over this failure to make your declaration in time?
I would think so. I would think that there are some documents. We have corresponded over the past 2.5 years, so there must be some sort of correspondence there.
So you will have copies of her letters to you, is that right?
Yes, I should.
Did you respond to the registrar in writing?
I may have responded by email. I cannot be certain, so that I would have to check. And those documents would be with the registrar.
Well, again, if I could ask if you could just check your own records and perhaps produce to the Commissioner the documents that you, or the exchange of correspondence that you had with the registrar, that would be most helpful. If I go now to your 2021 declaration, and we see that at page 51 in the bundle. Do you have it?
Yes.
Again, stamped by the registrar. It's dated the 11th of May 2021. If you go through to page 61, that's your signature, isn't it?
Yes, it is.
And you've dated it the 12th of March 2021.
That is not my handwriting, Commissioner.
Which bit of it is not your handwriting?
The date.
Can you explain how the date came to be there?
I have no idea, sir. It is possible that I did not date it and it was dated by someone else.
We'll help the Commissioner to understand this. How did you come to complete this form?
I filled the form out as far as I can see here.
So the other entries in the form, that's in your handwriting, is it?
Yes.
But you don't believe that the date is in your handwriting?
Not that I don't believe, Commissioner. I know it's
Certain
not.
that it's not your
That is
handwriting.
not my handwriting.
Now, in that case, I mean, on the face of the document, there is a discrepancy between the date that it's signed, that 12th of March date, and then the 11th of May date. But can you help at all as to when you did actually fill in the form?
I cannot recall. I know that the registrar was hospitalized and there was some back and forth in terms of when she would be back in office.
Well, can you help at all with, you would have been aware, I'm going to suggest that on the 12th of March 2021, you had to submit your declaration.
Yes, I am aware that it is the 12th.
Yes, and can you help the Commissioner at all with how close you were to that date this year?
I cannot say. I would think that I was a lot closer than the other 2 years, Commissioner.
If I take you to 7, please.
I'm sorry, have we, you completed the form, and what did you do with the form?
I gave it to my, my secretary that I share with another member, and it was sent in.
Thank you.
So can I, following on from what the Commissioner's asked, just ask you this, where do you get the forms from?
The form is sent from the registrar,
so
Commissioner.
Each year, does she send you a form to fill in?
Yes, Commissioner.
Well, if we go to 7, please, in the bundle. This is the first letter that the Commissioner sent to you in your position as a member of the House of Assembly rather than as a minister or junior minister. It's dated the 19th of February 2021. And if you go overleaf, you will see at page 8 the 3 requests that the Commissioner made of you. Which included, firstly, the date and content of each declaration of interest. Secondly, that irrespective of any such declarations you may have made, the information and documents that you would provide in such a declaration. And lastly, you're asked if during your period of appointment as a member, you failed at any time to comply with your obligation to make such a declaration pursuant to section 3.1, in respect of each such failure, a full explanation as to why you did not make such declaration. Now, your answer we find at page 10. It is dated the 12th of March 2021. It is in exactly the same terms as the letter that we were looking at from your colleague, the Honourable De Castro. And it sets out a full answer to the Commissioner's request. Now, is it right that, or do you agree with the evidence that Mr. Castro gave, which was that this was a joint letter collectively drafted by those on the government side of the House of Assembly?
Yes, I do, Commissioner.
And you signed it, and clearly you would not have signed it if you did not agree with the contents of that letter.
That is correct, Commissioner.
If you go to A, you say, as a member of the House of Assembly and since the introduction of the Register of Interest Act 2006, I have complied with section 3 of same in the form and manner as set out in Schedule 1 therein. Now, was there any reason why you didn't disclose in this letter that you had twice failed to submit your declaration of interests on time?
Can you repeat the question?
Yeah, if you look at your answer A, you've said, as a member of the House of Assembly, and since the introduction of the Register of Interest Act 2006, I have complied with Section 3 of same in the form and manner as set out in Schedule 1 therein. And my question is, was there any reason why, in responding to the Commissioner on the 12th of March, you did not disclose to him that you had twice failed to get your declaration in on time?
There is no reason. I consider that since I did submit it, that would be sufficient.
If you perhaps, do you have the legislation bundle there? If you can find it. It should say Constitution and Legislation Bundle.
Okay, and the page number?
If you go to page 59, first of all. That's the first page of the Register of Interest Act 2006. And if you turn to 61, Section 3, which, as you told the Commissioner you had complied with, it reads as follows. 3.1, a member shall make a declaration in the form set out in Schedule 1 within 30 days after this Act comes into force, and thereafter on the date on which he assumes the function of his office and on each subsequent anniversary of that date. And the point is that it can't have been right when you wrote that you had complied with Section 3, because you hadn't complied with the requirement in that section to submit it on either on the date on which you assume the functions of your office as a member of the House of Assembly or on subsequent dates.
I will say that I did not submit it on March the 12th of each year, beginning with 2019, but it was submitted, albeit being late.
Now, another point that you have in common with the fellow members of the government side of the House of Assembly is at B, where you say, I do not keep copies of my declaration of interest, and as such, I will not be in a position to assist you with the dates and its contents. Why do you not keep your declarations of interest?
Well, being a new member of the House of Assembly, Commissioner, I just did not make a copy at that time. And in the quest to get the documents in, since they were already late, copies were not made.
Can we look in a little bit more detail about what you have declared? I'm going to try and do this by focusing on one of your forms, and that's the 2021 declaration. If need be, we'll try and cross-refer you to the earlier forms. But if we start at 51, which I hope will be the first page of your 2021 declaration. Now, the first part of the form on page 51 is a preamble, and it says that the main purpose of the Register of Interest is to provide information of any pecuniary interest or other material benefit which a member receives, which might reasonably be thought by others to influence his or her actions, speeches, or votes in the House of Assembly, or actions taken in his or her capacity as a member. So with that in mind, did you, first of all, did you read that preamble when you were completing your forms?
I would have.
And when you read it, what did you understand the purpose of this declaration to be?
The purpose of the declaration would have been to disclose any businesses that you might be doing business with the government with.
Isn't it a little wider than that, Mrs. Flax-Charles? Isn't the point for you to set out in a record, an accurate record of any interests that might be thought by others could influence the way you behave and conduct yourself as a member of the House of Assembly?
Can I get some more clarity on that, please?
Well, the best clarity I can give you is to invite you to read the preamble to yourself.
Mhm. Okay, can you just repeat the question?
Oh, it's a proposition that I was putting to you, that the purpose of completing this declaration is wider than you had suggested, that the point of it is for you, as a member of the House of Assembly, to set out in one document any interest or benefit which might be thought by others could influence your actions or the way you conduct yourself as a member of the House of Assembly. That's the purpose of making this declaration, isn't it?
It would appear that way.
And that's why it's so important for it to be up to date as well as accurate. And that's why it matters, doesn't it, when people are late with their forms? Would you agree?
I would agree. It was late. I've already accepted that fact. I have already stated that I was late and I cannot go back on that.
Can we look at how you completed the form to sort of get an understanding of how you approached it as a member of the House of Assembly? I've been calling them categories, but I'm going to adopt the Commissioner's wording of paragraph. So paragraph 1 asks about your directorships. Now in 2021, you had said no to that. Earlier, we'd looked at your 2019 declaration where you referred to Flax VI Limited. And that's, if you need to look it up again, at page 83 or possibly 81. But what had happened? You didn't refer to Flax VI Limited in your 2020 declaration. So what happened to that company after 2019?
That company no longer exists.
The paragraph 2, which is at your page 53, is the next section that you're then required to fill in. And that is remunerated employment office profession. And you've there referred to Anver Productions, and you say musical band vocalist. Now, in 2019, as we looked at earlier, you had referred to the boutiques, the Virgin Gorda Music School, EcoBuild BVI, but you didn't fill those in 2021. What had happened to those?
Because of the hurricane of 2017, the Virgin Gorda Music School, the building that housed that school, was totally destroyed, inclusive of all of the musical equipment used to teach the children in the community. Island Silhouettes, that business was closed because of the hurricanes as well. I'm trying to find that document.
If you go to page 84, I think it's either 84 or 82 for you.
Yes, those businesses were closed after the hurricanes, with one reopening shortly, maybe 6 months after the hurricane.
the hurricanes are in 2017.
Exactly.
In your 2019 declaration, you are referring to the boutiques and to the Virgin Gorda Music Schools. That's 2 years after the hurricanes.
They were closed. The music school has not reopened since the hurricane. It is still closed.
So are you saying now that it was an error to refer to the Virgin Gorda Music School in your 2019 declaration?
I would have to say that. Okay, I see where I made my error. There's remunerated and unremunerated. So the school has not been open. So that is an error.
Should it have been omitted from the form entirely, or should it have gone somewhere else on the form? Is it still a business that's there?
Well, the trade license is not up to date at this particular point in time. So it is still a business on paper, and we do intend to reopen. However, the building still has not been repaired.
Okay. The two boutiques, you said one was reopened some 6 months after the hurricane. So
right.
What has happened to that business? Is it still an active business?
It is. I am not involved in that business on a day-to-day basis.
See, and do you receive any kind of remuneration from that business?
I used to, and I used to get some remuneration from that.
See, and is it a business that you own, or is it a company that you're a director
It's
of?
not a company. All of these businesses are DBAs.
I see. So they're not businesses in which you own shares or anything like that.
No, sir.
Just simply DBAs, and you either get remuneration from them or you don't.
Exactly, sir.
And essentially, after 2019, is it your evidence that you got no remuneration from the boutiques, the music school, or EcoBuild BVI?
Exactly, sir. The EcoBuild BVI is not functioning. If you notice, I have a list of trade licenses. Some of them are functioning, some of them are not.
I see. I'm going to take you to the trade licenses in a moment, because I'd like you to explain that document to the commissioner yourself. So what I want to do is just take you through the different paragraphs first to see where you are. So if we go back to page 53, when I asked you about Anva Productions and where it was at in 2019, you said that the studio had also suffered in the hurricane, but at least in 2021, from the point of view of being a musical band and you as a vocalist, I assume, that's the present state of Anva Productions, is it?
Yes, it is. It's Anva Productions falls under one umbrella: recording studio, musical band. And then there's some other side, like a DJ service, etc.
And is your remuneration from that simply as the vocalist in the band?
Yes, it is.
Now you, if we go to paragraph 3 at 54, that refers to clients, and to summarize it, it's intended to ask a House of Assembly member to declare any services they have provided through being a member of the House of Assembly to clients of their other businesses. So in your case, you've not had, for example, to make representations on behalf of others to ministers or anything like that. Is that right?
I'm not understanding your question.
I'm trying to take paragraph 3 quite quickly. It refers to where you are a paid employment, either as a director or that you're remunerated. If that work involves the provision to clients of services which depend upon you being a member of the House of Assembly, then you have to declare it. Now you've answered no. So it is the position that you have never, if you like, provided those services to clients.
Based on me being a member of the House?
Yeah.
No, I have not.
What I'd suggest is that the purpose of it is if you use your position to help someone have access to a minister or something like that.
Not at all.
Let's go to paragraph 2 then at 55.
Paragraph 4.
Paragraph 4, sorry. So it refers to sponsorship, it's titled sponsorship. The first question that you're asked to answer is, did you benefit from any sponsorship before election where, to your knowledge, the financial support in any case exceeded in aggregate $2,500? And if you look at the bottom of the page, Mrs. Flax-Charles, you see that what the note says is you should register money given to you by your election campaign committee and money spent by your election campaign committee in connection with your election with your permission. So it seems to be directed to asking members of Assembly to declare funds they may have received for the purpose of their election. So in your case, it takes you back to 2019. Now, what did you understand to be required of you in answering that question?
In aggregate of 2,500 would mean that overall, if anything was over 2,500, you would have to declare it.
Whatever source it came from.
Exactly, if it was over 2,500.
And in your case, that didn't happen. You didn't receive funds over 2,500.
No, it did not. No, I did not, sir.
Now, the Honourable De Castro explained that the position is somewhat different if you're a territorial candidate because you don't have a district committee. So how is your campaign as a territorial candidate financed?
Whatever I did, it came from my pocket.
So you didn't receive any kind of sponsorship at all. You paid your way through your election. Is that the position?
Basically, that's what I did. Being as conservative as possible, even though I was an at-large candidate at the time.
Now you say it all came from your pocket. What role does the party play in supporting your campaign?
I'm not 100% sure what all the party does. We show up at the rallies and so forth, do what we have to do. And I made sure all of my paraphernalia, the giveaways, whatever it is that you pass out with your picture, your slogan and so forth, all of those things I purchased on my own.
See, so if there was party support of your campaign, that was something that was unconnected to you.
Exactly.
Okay, if we look at paragraph 5, well, before we leave paragraph 4, what you're also asked is to declare any benefit from any form of sponsorship or financial or material support as a member of the House of Assembly. And you've not received any kind of benefit or financial support.
No, Commissioner.
If we go to 5, gifts, benefits and hospitality in Virgin Islands, have you or your spouse, to your knowledge, received any gift of a value greater than 500 or any material advantage of a value greater than 1.5% of the current salary of an elected member? You've answered no to that, as you've done every year. And that's the case. You've not received anything that brings you within this paragraph.
I have not received anything as it relates to paragraph 5, Commissioner.
Paragraph 6, overseas visits, and this relates to whether you've had, again, in your capacity as a member of the House of Assembly, an overseas visit that was not funded either by yourself or from the public purse. And again, during your time, that's never occurred to you.
No, it has not.
Nor, if we look at 7, have you received any overseas benefits or gifts as a member of the House of Assembly?
No, I have not, Commissioner.
Paragraph 8 at page 59 is land. And you, if we go back to page 90 for a moment.
19?
90,
90.
please.
Well, it would probably be my 88.
Thank you.
Yes.
This is the declaration of land. What you're asked to provide is, do you have any land other than any home used solely for the personal residential purpose of you or your family? Now, what you've declared is, this is in 2019, your home in Princess Quarters and then a rental property in Princess Quarters. When we go to 74, in 2020, again, I'm sorry, it's either you're 74 or 72.
I think that might have been omitted. Is it the same document that speaks to land?
Yes.
I think there's a page missing between.
There's a page missing, it would seem.
Between 73 and 74. 73 and 74 in our copy, Mr. Wright, go from overseas benefits and gifts.
All right. Well, if I
10.
What you declared in 2020 is the same as you declared in 2021. If I take you back to 59.
Yes.
Yeah.
Thank you.
In 2019, you said?
So in 2019, you had a home and one rental property. When you got to 2020, which is the missing page, you actually gave the same information as you gave in 2021. So if I take you to that, we can deal with it.
Yes.
And that's at 59. So in effect, your declaration is that you have a residential property in Princess Quarters, and that's your home.
Yes, sir, that is.
Used for the personal residential purposes of you and your family.
Yes, Commissioner.
Separate to that, you have one rental property in Princess Quarters.
Yes, Commissioner.
And then there's a vacant property in South Valley that you co-own.
Yes, that is correct, Commissioner.
And that's the full extent of the land holdings that you have.
Yes, Commissioner.
Paragraph 9, if you go to page 60. Your declaration has been that you have no shareholdings, is that right?
That is correct, Commissioner.
I'd now like your assistance, please, to explain the document that you annexed to your 2020 declarations and your 2021 declarations. And if you go to page 62, it's headed Trade Department Premier Office. Have you got that, Mrs. Flax-Charles?
Yes, I do, Commissioner.
Can you explain what the purpose of this document was?
Well, to be honest, Commissioner, full disclosure.
Can you expand on that a little bit? What did you want the registrar to understand from giving her this document?
I just wanted her to understand that these were all of the businesses. Some of them are not in operation, either owned by myself, my husband, and my 2 older children who are adults.
And so you went further than you're obliged under the Register of Interest Act?
Yes, I did, Commissioner.
And what you were giving her were the trade licenses that were in place as of the time of making the declaration, is that right?
Yes, Commissioner, whether they were active or not.
Looking at it now, do you think it would have assisted the registrar if you had been able to tell her which trade licenses were active and which were not?
That is correct. I would say that would have been something that we could have done.
If you go back to 61, it's paragraph 10. which asks you as a member of the House of Assembly to do this. It says, if bearing in mind the definition of purpose set out in the introduction to this form, you have any relevant interests which you consider should be disclosed, but which do not fall within the 9 categories set out above, please list them. So it takes you back to the preamble and asks you to give further information. What did you understand the purpose of this paragraph to be?
Relevant interest would mean other businesses or that you might have, other organizations that you might be involved with. But that is not the reason why I submitted the trade licenses, because they ask upfront what companies or other businesses you might have.
What the form asks you to do is, as you go through categories
Right.
1 to 9, is to declare directorships.
Right.
It asks you to declare where you might have other employment from. It asks you to declare land that you might hold that's more than residential. And it asks you to declare shareholdings, either yourself or with or on behalf of your spouse or dependent children. Isn't the purpose of paragraph 10 to go further than that, and for you as a member of the House of Assembly to list anything else that might, going back to the first page, be thought by others to influence your actions or conduct as a member of the House of Assembly?
I would say that is what I understand it to be.
And so, was there any reason, given you said that you wanted to make full disclosure, was there anything, thinking about it, that you ought to have put in paragraph 10 on the form?
Not that I can recall. I don't see anything else that would have been relevant when I filled the form and submitted.
This is a question I put in to the Honourable De Castro, but if, for example, you had a relative who had secured a government contract from the government of which you are a member, do you think that's something that you might need to record in paragraph 10?
Based on what I consider a relative, and based on the documents and the definition of a relative, it would have been spouse and dependent children.
So you read the act or the requirements on you as only requiring you to give information about yourself, your spouse, and your dependent children?
Yes, Commissioner.
Now, a member of the public reading or learning that, for example, a government minister's relative had secured a contract might conclude that that is information that, or that is something that could influence the actions of and conduct of that member. Do you agree with that?
I would agree with that from the public's perception, Commissioner, but I must add that the public perception and what is reality in the BVI are far apart.
But in order to bring the perception and the reality closer together, isn't an approach of full transparency beneficial?
I would agree with that, and that is why I am in favor of the legislation that we are bringing, different legislation that we will be bringing to the House across the board, so that everything is clear both to the public and to elected officials as well as senior public officers.
How things are made clear to the public may depend on what information is included. Would you accept that if paragraph 10 is construed more widely than you have done, that may mean that the public have a better understanding of the interests held by the members of the House of Assembly?
Yes, Commissioner, and I would go a step further to say that in the last couple of months, we have been having public consultations on a lot of the legislation that is to come before the House. So the public will have a better understanding of what we're doing as a government, as a House of Assembly.
But if we focus on paragraph 10, if that guidance, that paragraph made clear that it wasn't limited just to yourself as a member of the House of Assembly, your spouse or your dependent children, but that you should look at it more widely, that may help with the public perception of how members of the House of Assembly are up to.
I do agree with you. I would never disagree with that. And that is why we are seeking to amend the Register of Interest Act in order to ensure that the public is aware of what our interests are.
I mean, I understand that. And the evidence from the Attorney General is that the registration of interests bill is really at a very early stage. It's been drafted. We have the draft. I don't think it's been to Cabinet yet. It certainly hasn't been to the House yet. But the current draft does not propose any change to paragraph 10. So that it may change as it goes through the system, but it doesn't propose any change yet.
What I would say, Commissioner, when the bill leaves Cabinet, it comes to the House for the first reading, and then the second and third readings, we go into what you would call the committee stage, where that bill is picked apart, and that is where those changes can be made.
No, I understand that. Yes, thank you.
So to bring the threads together, please, Mrs. Flax-Charles, would you agree with, or would you be supportive of a form that ensured that members of the House of Assembly did not just limit their declarations to themselves, their spouse and their dependent children, but also to any interests held by others which might be thought to impact on their conduct as a member of the House of Assembly?
Absolutely, and I would preface that to say almost everyone in the British Virgin Islands is related to each other.
That may mean that the detail of the guidance needs some work, but the principle is one that you would support.
I absolutely would support that.
Because on the construction that you've offered, the problem would be, and I am using a hypothetical, but if you have an adult sibling who has entered into a contract with the government, that is not something on your construction you would need to put in this form, but it would be something that surely the public would benefit from knowing, because it is something that the public might think, well, might influence your conduct. Would you accept that?
I agree. I agree, Commissioner.
Thank you. Can I just take you, I think I'll move on to the same questions that I put to the Honourable de Castro. And that is just to, and hopefully we'll do it more shortly because of her answers, but so I'm going to put a set of propositions to you based on the evidence that your colleague gave. And the first is this, that as a territorial representative, you also have access to the funds that allow you to give assistant grants.
Yes, Commissioner, I do.
And do you agree with the evidence that we received as to the process? So firstly, there's an application form, and you, as a member of the House of Assembly, approve or reject the application. Is that right?
Yes, it is, Commissioner.
And if you approve it, it then goes to the clerk of the House of Assembly, and then it then goes to the Treasury Department for final sign-off and payment. Is that right?
That is correct, Commissioner.
Is it also right that you're given $150,000 a year as a territorial representative to use?
That is correct, Commissioner.
And taking 2019, 2020 as an example, in that year, did you distribute the entirety of the $150,000 that was allocated to you?
In the first year, Commissioner, I believe that there was a small balance that was left back. Applications were submitted, but December is a very crazy month, and some of those applications were not processed.
My understanding from the Honourable De Castro's evidence is that the payments are made to individuals, as well as entities such as schools that might seek sponsorships. But in your practice as a member of the House of Assembly, have you ever paid out sums to a business?
What I would say, Commissioner, is schools, organizations, businesses will only get a payout if someone, an individual, requests assistance. And then I can give an example, if they're having difficulty paying a bill, then it would be paid to the business, as in the case of someone needing surgery, life-saving surgery, that can be done here in the British Virgin Islands. That check would be made to the particular clinic.
But what isn't the case is that if a commercial business knocks on your door and says, we'd like X amount of money out of as an assistant grant, that's not something.
No, that is not something that I would do.
Do you know what's whether there is a maximum that you're allowed to pay out?
I am not 100% sure. I believe if there is any amount over 10,000, it has to be signed off on by the Premier. That is my understanding.
And were you given guidance by the clerk to the House of Assembly as how you should operate this system?
Yes, there is a document. I cannot tell you every single thing that's in that document without being able to refer back to it at this time, Commissioner.
Can you help with this point, which the Honourable De Castro couldn't, and that is the position of family members? I mean, if a family member, her understanding or her approach is that if she has an approach from a family member, the answer is no. Now, in those circumstances, if there is a deserving case who happens to be a family member, how do they get help?
They would not get help from me, Commissioner.
Can they get help from others?
They can get help from others if they apply to another member, whether on the government side or on the opposition.
And it's perhaps different because you're a territorial representative, but are you permitted under the scheme to support that application in any way?
No, we don't see each other's applications, Commissioner.
And do you agree with the evidence of Honourable De Castro, who said that the fund can also be used to fulfill policy promises of yourself as a candidate?
Yes, we do sponsor different programs throughout the territory as an at-large representative. So I can give you an example. A young man wanted to do a project with children in the community where they planted a herbal garden at the elderly home in Virgin Gorda. Things like that we do. We sponsor schools with projects, murals, and the like, where young people are able to get involved and be a part, because we do have a program where young persons need community hours in order to graduate from high school. And so a lot of my focus is on assisting young people.
It might be suggested that giving a member of the House of Assembly of whatever party a sum of money that they can use in this way, that to an outsider might suggest that it looks like vote buying. How does the system guard against that allegation?
Well, Commissioner, we have to do due diligence. Sometimes things might fall through the cracks, but I can only speak for myself. I try my best to investigate, to make sure that the claims and the applications that come in are legitimate. And as we mentioned before, there's a process. After it leaves the member, it goes to the clerk and then to the treasury. And I must say this because there are lots of people. Even before the hurricane, I wasn't an elected member then. But in my community work, there are lots of people that are suffering in the BVI. We do not have a welfare system like the United States does. And I would like to think that as a member, if someone comes and needs help and we investigate and it is legitimate, especially in cases of help, we see a lot of that. It's about saving a life. It's not about buying a vote. And we've had those instances. Right now we have persons who need a kidney transplant, persons who need a pacemaker, and the list goes on and on. We are never able to fulfill all of the requests. I can take a guess and say, as a territorial member, I probably have over $3 million in requests that I will never be able to fulfill. And you have to prioritize, because how do you decide to give an individual money to pay their electricity bill and someone whose life needs to be saved by assisting with a kidney transplant or heart surgery or whatever type of surgery it is? So I do not consider it as buying a vote. I consider it truly as really being able to make a difference and to help persons who really and truly need the help.
If you have a situation, I mean, you've explained that in effect you get more requests than you can fulfill. And you obviously start the year with a certain amount of money, and as requests are answered by you as a member of the House of Assembly, the sum diminishes. What is the position of someone who, towards the end of that year, does need support and is a deserving case, but if you can't fulfill that request, where can they go to?
The only other place they can go to is, well, not the only, they can probably, Commissioner, go to the Social Development Department, or we refer them to organizations such as the Rotary Club and the Lions Club, who do offer assistance, the Family Support Network, and places such as those, because we get a drawdown of $37,500 every quarter. So we do not get that full bulk of we don't get the whole 150K at the beginning of the year. So we also lean on the other agencies and nonprofits to assist us with helping persons. So if we cannot help, we refer them to those agencies and others that I have just mentioned.
And are you required, you've explained the due diligence that is done, are you required to keep records of how you are distributing the money?
Yes, we are, Commissioner.
Are you audited at all?
I am not 100% sure of that. I know that the clerk is the accounting officer and she keeps track of whatever we do and how whatever we spend in terms of the allocation that we receive.
Would you, Honourable De Castro's evidence was that she would support a proposal that details be published as to how funds are distributed. Is that something that you would also be in support of?
Absolutely. I have no challenge with that at all, Commissioner.
You will have heard today, or you may have heard today, that the Commissioner has asked questions of witnesses as to whether there are any rules in relation to party financing and campaign financing. Would you agree that if the Virgin Island authorities legislated and instituted policies for candidate and party financing and for the registration of political parties for financial reporting purposes, that would only increase trust in the system, and it would also reduce the risk of corrupt practices emerging?
I would absolutely support that. I will agree with that.
In your own stance, Mrs. Flax-Charles, are you a supporter of reform of party campaign financing?
Yes, I am, Commissioner.
Can I turn to another matter that I also put to the Honourable De Castro, and it's this, and it takes us back to the Virgin Island Constitution of 2007. Section 67 of that Constitution provides that if you, as an elected member of the House Assembly, were to be a member or a director or a manager of a company that's contracted to business with the government, then you have to vacate your seat unless you are exempted by the House of Assembly. And there is provision within the Constitution for the House of Assembly to exempt you from that requirement to vacate your seat. You've been a member of the House of Assembly since 2019. In your case, have you been exempted from vacating your seat under Section 67?
I do not have any contracts, or none of my immediate family have contracts with the government, nor do we intend to.
Just to make sure that we're specific, what Section 67(7) refers to is a decision of the House of Assembly to exempt a member from that requirement. Have you haven't been, it's your evidence you haven't been the beneficiary of such a decision?
No, I have not.
So may I have a moment? Sorry, please let me finish.
What I would say is, if someone becomes a member and they've had an existing contract with government, there would need to be something in place for that, legally and otherwise. Because if a member was elected but had a contract that spans over into their term in office, something has to be in place to at the least ensure that the employees of that company still have a job. So I don't know if I fully understand what you're asking me, but.
Well, you've taken it wider and you've suggested that where you have if you like, a rollover, so you've got a contract with government and then you enter government yourself or enter the House of Assembly. So you said something has to be in place. So do you know whether there is a mechanism or scheme at the moment?
I believe that there were some resolutions that were passed in the House some time ago for some members that had contracts with government before they were elected. And so we need to look at it from a broader perspective, Commissioner, I like to look at things from how it affects the lives of people and families and so forth. And so for me, if a member getting elected in 2019, but in 2017 signed a contract with government, and that contract stretches over into up to 2020, 2021, let's say, there must be something where that person can be safeguarded in the sense of their employees. Because if that contract were to just stop when a member becomes elected, what provision is there for the employees and the families of those employees?
No, I say that's not your case, because
no, it's not.
It's a hypothetical case, but I mean,
yes.
it's a real hypothesis that a candidate may be elected. Candidate has a contract. What happens to the contract when he or she is elected? Because there are, as it were, real people involved in terms of employment and so on.
Right. So Commissioner, that is something that I believe that we would look at a lot closer, just to make sure that there's full disclosure all the way around. We are committed to that.
No, I understand. Thank you very much.
As you've explained, Mrs. Flax-Charles, it's not a situation that relates to you, because you haven't entered into a contract with government either before or since becoming a member of the House of Assembly, and that situation applies both to your spouse, your children, dependent or not, or indeed other members of your family. Either at any point they haven't entered into contracts. But you're nodding yes, but I'm going to ask the Commissioner now if I could just have a moment.
Yes, certainly, yes.
Commissioner, Mrs. Flax-Charles, I have no further questions. So if I could just conclude by thanking Mrs. Flax-Charles for coming today and giving her evidence, and for the way indeed in which she has given that evidence. Thank you very much.
Could I just ask two final questions, just to clarify your evidence in relation to the distribution of the funds, and you've gone into that in some detail, thank you. The first is Mr. Castro said that in terms of checks and balances on the way the discretion to distribute is exercised, and we're waiting to see the policy document that's going to be produced. But she referred to two, really. Two, but within the same process, and that is that the application, once it's been signed off by the member, then goes to the House of Assembly clerk to be signed off by her, and then goes to the Treasury to be signed off by it. Are there any other checks and balances that you're aware of?
Not that I'm aware of, but I will say that I have had the experience of having a document, an application returned. So I think the process is working. I would not say that it doesn't need to be improved, because anything can be improved upon, but I have had that experience, so I know that it's working.
But was that something, if you can answer this question, was that an application that was refused, as it were, because of the merits of the application, or because some document or wasn't provided or box was not ticked?
In one case, there were documents that were not provided, and in other cases, another member had already given that person assistance.
I understand that, and that's really the second. It is a question, but it's really a concern, really. This money, 1.8 million between all of the members, $150,000 each, is distributed as you said. I mean, it's in good part, welfare payments based on need, but not only, because prizes for schools, community projects, that they all can benefit, can probably benefit from these funds. So it's not purely welfare. And you've said that the requests that you get, and I'm not sure that you'll be any different from any other member, is something like 20 times the amount that you have to give away, £3 million a year in terms of requests. And in terms of the exercise of discretion, it seems to me that that's a complete nightmare, because you have to decide whether money goes to, well, I mean, you've used the examples of somebody who needs an important, if not vital, operation, somebody who may have another financial need, or a school that wants a trophy. I mean, and you have to decide, exercise your discretion in respect of all of this. And it seems to me, as an outsider, that it's a bit of a ramshackle system, even though, as you said, you do, you do your best. You do your best. But it's the exercise of a very wide discretion, without, one suspects, we haven't seen the policy document yet, a huge amount of guidance. So it's a big burden on your shoulders, or on the shoulders of any member.
Yes, it is, Commissioner, and I would say as well, the district representatives, they get a little bit less. I cannot remember the figure, but the at-large gets a little more, since we have to cover the entire territory.
Yeah, I see that, but also, and this is reflected in the answer, in the information you gave about the application that was refused. As a BVI citizen here, if I want a payment from a member, I have 5 members to choose from. The district to make an application, the district member and the 5 territorial members.
Yes, sir, that is the case, and most persons would send 5 applications. So you have to be very, very careful, and I have to give kudos to the clerk and the team at the Treasury, because they do pick up on it.
Yes.
When when a member submits the same application, same documents, everything.
2 members may submit as it were the same application.
Right. Yes, it has happened before, at least in my case, but.
Well, it's bound to happen.
Yes,
I mean,
it
it's bound
is.
to happen from time to
yes,
time.
we have to tweak the system a little bit more.
Thank you very much. And unless you've got any further questions, Mr. Wright, just to thank you, to join Mr. Wright in thanking you for coming, giving your evidence, and giving it so clearly and helpfully. Thank you very much.
Thank you.
Mr. Wright, is there anything else?
Nothing more for us to do today.
I think again there are 1 or 2 pieces of information and documents.
Yes,
Ms. Flax-Charles
I think
said she would
the only
provide.
thing we have is Mrs. Flax-Charles is going to provide us with her correspondence with the registrar.
Good. And perhaps if we can agree with Mr. Olympitis, the list of things which the 2 members, I don't think there was any from the Attorney General.
No.
That I think would help everybody.
Yes.
Good. Unless there's anything else. Thank you very much.